last month.
Yes.
You to fix the matter as previously. Now it is at 67 today. She finally fixed any date of this week. Any date. This is very urgent.
Mention matter. List number, item number 67. Item double. 67. Okay, let me take up today's list first. Let's see how we can proceed.
May I permit to mention one matter, my lord, for application, my lord?
For what?
Application, my lord. For
Under heading?
income,
Under heading?
Under the heading application.
Application. Group 8 matters.
In group 1 matter, my lord. Group 1. And another, my lord, for upgradation, my lord. Another, my lord, motion matter 100, my lord, 199, my lord, for upgradation, my lord.
No upgradation.
This is very urgent.
No upgradation. All are urgent
They are
matters.
going to be
Let run the list first.
matter will be impacted.
You know I was not there for 10 days. So when how can I? Item number?
This is
for listing. For listing under heading application. Group 1 matter.
Group 1 matter.
Group 1 matter.
Group 1 matter.
This is also group 1 matter. Group 1. Group 1 matter. The contempt matter.
Contempt matter. I only visit your loss. Contempt matter. Because my lord, in this matter, what happens to your lordship order?
Now, whether they have preferred an appeal, I think.
Yes, appeal has been filed, but no stay order. Stay has been refused. That again, court order on the admission your lordship directed them to file the affidavit. They are not filing the affidavit. Already, your lordship give them 2 weeks time. They are already taken for 1 month time has been extended.
Both the matters, Subroto and Devotos Notto.
Both the
So it is under the heading contempt application. Let me run the list first today.
any date contempt.
Today is the day. So what can I do?
My lord, may I have your lordship's kind leave to mention, my lord, for extension of interim order, my lord, it is lapsing on 8th of August, my lord. My lord, group 8, my lord, only thing, my lord, the matter is appearing as item number 94 in today's list. Today's list, my lord. It is appearing. My lord, for extension, my lord. Because
let the list be run first.
94, my lord, most probably it will not
let
be.
Me see, let me
see. No, my lord, kindly. No, my lord, not today, my lord. It will be, my lord, the interim order will lapse, my lord. Kindly.
When interim will lapse?
8th August.
8th August. Today is?
Friday. Friday it will lapse. And tomorrow, my lord, if your lordship doesn't take up the group 8 matter, my lord, then, my lord, it will be but the interim order will.
Item number?
94.
94. Yes. 94.
94, my lord.
To be mentioned matter?
Mentioned matter, my lord. 94. It has gone to 94.
93 and 94?
93 and 94. My is 94, my lord. Interim order is in 94.
If not taken up today, tomorrow I will take up this matter.
Kindly keep it as extension of interim order tomorrow, my lord. Then, my lord, kindly.
If not taken up today, I will take up this matter tomorrow. Okay.
My lord, my lord. My lord, I am handing over the slip, my lord.
Not necessary.
And my lord, one.
Item number?
41.
Yes.
It's a matter where one of the filings of the act. Controller was under challenge regarding one of the entry point in the by shop 45 years. But you will also pass an entry order thereafter division bench directed an order with kindly go to 3 paragraphs of the order of the division.
You have already mentioned it.
No, this matter was fixed by your lordship at 10:30. I concluded my submission. So for the state is concerned, session of the is appealed. You have to kindly fix the matter at any day at 10:30 because at least 15 to 20 matters are pending with your lordship. And upon military's license is being issued each and every day. 41.
Because division bench also requested your lordship to early disposal of the matter.
I understand, you know the situation is
At any day 10:30, otherwise, my lord, every day they are issuing the license.
10:30 is not possible.
11 o'clock or
I can
10:30,
fix a date.
12 o'clock at any time. Early, other time.
I can fix a date,
Based upon the
not before 18th of August. Not before 18th of August. Let it run in the list. Otherwise,
wait, my lord.
18th of August, 2 p.m.
Okay, my lord, division bench matter is also going on. Any day.
Then 19,
My lord, because it will not take more than 1 hour. Both
19, 2 p.m.
or item number 1, my lord. Otherwise, there are
Just wait. 19th August, কিছু আছে?
because none of the observation of your lordship has been interfered with by the division.
কিছু আছে? Please take down. On mentioning this matter be listed on 19th of August 2025 at 2 p.m. as a specially fixed matter. Item number 41.
Your Lordship, may I have Your Lordship's kind leave to mention an application, Your Lordship, for extension of interim order. Your Lordship, my extension
1
was
or group 8?
Group 3, Your Lordship. This is a assigned matter, Your Lordship.
Assigned matter.
Your Lordship. Your Lordship, the urgency is that the certificate officer has fixed the date on 11th of August for bringing the check, Your Lordship. Your Lordship has passed an interim order. The interim order is expired on sometime in the March, Your Lordship. Filed within time. Your Lordship, this matter was mentioned several times, Your Lordship, but this matter didn't appear in the Lordship.
Whether it is in the list?
Your Lordship, it is not appearing in the list, Your Lordship.
ঠিক আছে তখন আপনারাও তখন আমরা
This next one. Just wait.
নেক্সট গ্রুপ
Yes.
One group 8 matter, Your Lordship might have remember that
Obliged, Your Lordship.
DPS stock was suspended, but after the inspection, the all stock was okay. That day, the other state took time for giving one report. Your Lordship, it will take only 2 minutes, Your Lordship. Petitioner shop has been suspended.
Whether it was listed,
It is listed, Lordship, 150.
list number.
154, today's item number, Lordship. Kindly.
So what you want? No upgradation today. No upgradation today. You know this code was not there for 10 days. How can I upgrade? Let the list be run.
বলা আছে
17 and 23, my lord, though I'm praying for upgradation, my lord is hard pressed.
No. Today I want to run the list.
So allow me to come on Monday.
Only 2 minutes.
If it is not taken up this week, my lord, may I come? 17 and 23. License will be issued.
Item number
217 and 223.
217.
Yes, my lord. And 223. These two matters, the license will be issued at any point of time. If it is not taken up, allow me to come on Monday. I'm not doing.
It will appear on Monday. No issue.
No, not appearing for the purpose of upgradation, my lord. That is why appearing is also.
Today I am
No,
not
I'm not
upgrading any
disturbing your
matter.
lordship. My lord, I'm not disturbing your lordship.
If not taken up today, it will appear on Monday and I will upgrade that then. Okay.
My lord,
May I have your lordship?
Just the diary be there. List
But-
be there. Thereafter I will pass the order.
Madam,
My
may I have
lord,
your
may I be
lordship's
permitted
kind
to
leave?
Again,
My lord, kind leave to mention, my lord, one Jalpaiguri matter, my lord. My lord, this is with regard to vacancy matters, my lord. Your lordship
why
knows.
Jalpaiguri matter appearing to me?
আমরা
My lord, I'm praying for leave before your
No,
lordship,
no,
my
no,
lord,
no
to
leave.
move.
There are some
To
arguments
file a-
on behalf of the parties that Jalpaiguri matter should not be taken up by this court.
Well, let it be
There are
filed.
Jalpaiguri matters.
File before your.
Why it is before the Jalpaiguri? Why before this court?
Well,
There
similar-
are certain objections on that point.
My lord, the point is, my lord, your lordship has heard the matter, my lord.
I know the merit
Similar
is- I
matters,
know
my lord. Your
similar
lordship
matters
knows.
I have
So,
passed
my
the
lord,
order. No. Jalpaiguri matter I cannot take up.
My lord,
You
may
have
I
to
be
file with Jalpaiguri.
My lord, may I be permitted to mention one motion group 1 matter for inclusion, my lord?
My lord, item number 11 of today's list.
এই পাশে একদম ডান দিকে যে ভদ্রমহিলা আছে না
My lord has a
ওই যে
division bench
এই যে একদম
I know today.
So, my lord, if not taken up, can it be fixed?
So what be done in these matters?
My
So
lord, the Union of India
I
is
know.
to resume their argument.
whether they are
I have informed Mrs. Alam, my lord, that I will be mentioning this matter today itself. She will start. So, my lord,
okay, whether she is available
She's-
now available.
She's now correct.
Very good. I will next fix the matter on next Wednesday. No issue.
Next week, 2 p.m. I will
Next
inform the others.
Usually next Wednesday it will be appeared
At 2 p.m.
at 2.
My lord, contempt application.
Content application for listing.
Your Lordship.
My lord, item number 319, my lord. My lord, this is a my lord, appointment of my lord, fair price shop. My lord, respondent has filed a report. Your lordship fixed the for hearing matter. My lord, it's a very short matter. My lord, any day I have filed an can application for expeditious disposal of the writ petition. My lord,
There is no
my lord,
upgradation.
any day, my lord. Then my lord, Monday, my
No
lord.
upgradation.
Then my lord,
Monday it will appear in the list. No issue. You
Then-
mentioned on Monday.
yes.
Your Lordship, may I mention one matter? This is an assigned matter before Your Lordship civil revisional application. Lordship, this is a suit for restoration of possession under Section 6. Suit was dismissed, Your Lordship. This is a non-appealable suit. This is why revision has been filed. Your Lordship, matter has not yet been taken up once. So there is no interim order. Your Lordship, I have been informed that they are trying to create third-party interest in the property. I believe Your Lordship is not updating the matter today, but if Your Lordship can kindly fix any date, Your Lordship. If the-
Item number
82, Your Lordship.
there in the 82. 81, 82. Two matters.
82, Your Lordship.
Your matter 82.
82.
It will be appear on Monday.
Your
Okay.
Lordship, kindly fix the time because if
No time. No such time can be fixed like that. Yes.
I have your lordship's kind leave to mention, my lord, two assigned civil divisional application, my lord, which may be taken up anytime as your lordship.
Assigned matter.
Assigned civil division, my lord.
My lord, may I be
Lordship, please.
sorry, sir. Sorry, sir. Sir, may I be permitted to mention one group
Your
one,
appeal. No, group 1.
group one matter. My lord, I was the bidder. A bid was occurred.
Want listing.
My lord, bid I have became the
What do you
best
want?
bidder.
Whether it was listed.
My lord,
You want listing.
my lord.
Group 1 matter. Yes, Mr. Huda.
My lord, for my lord, correction of an order dated that 14th of July 2025, my lord. Lord, Mr. Dotto, my lord, had argued the matter, my lord, and he was represented, but my lord, his name does not appear in the order, my lord. But for just for
For correction. Tomorrow for correction.
Your Lordship, may I permit to mention one non-prosecution? Petitioner does not want to proceed with the writ petition. May I hand over the same?
Monday.
And another matter, item
Monday. Under heading 2 mention. Yes.
item 220 of today's list, Your Lordship, there is some urgency in this matter because vacancy has been declared. Thereafter, writ petition was filed before Your Lordship. Then Your Lordship was pleased to direct the state respondent to file opposition. The opposition, we have seen the order of rejection of the petitioner regarding compassionate appointment. The petitioner withdraw the matter and file a face. In the meantime, vacancy has been proceed by the state respondent. For this reason, urgency, if Your Lordship kindly take it up Monday under heading mentioned matter.
You mentioned it on Monday. No, not today. Upgradation. Come on Monday.
What happened? Just I am reminding your lordship. What happened? This matter I have mentioned this matter. Thereafter, I filed this matter. What happened in this matter? A license is going to be issued in favor of a person who is a civic volunteer, who is doing the job of civic volunteer, and my candidate has been rejected. Therefore, they are going to issue the license.
I think there is an order by this court regarding civic volunteer like that.
Order. But so far, my rejection.
Justice Vivek Chaudhary has passed an order
So
thereafter.
far, my challenge is concerned rejection of my candidature. That is on challenge.
Okay.
My
I
lord,
will take up this on a Monday.
my lord, item
No
number,
upgradation today.
item number 3, my lord. Your Lordship fix the matter on the last, my lord, Monday. But
Item number 3.
yes, my lord. In this matter, my lord, Your Lordship fix the matter any day.
Today is the day I can take up this matter.
Yes, my lord.
If
Today,
we
my lord,
proceed.
it is not possible for me to.
Item number 3 I will take up now.
My lord, it is not possible
Specially
for me
fixed
to. my
matter,
lord.
Mr. Mukherjee.
Whatever may be that specially fixed matter was fixed on last Monday, my lord.
No.
That is on 4th, not 6th.
No,
So-
you know, Mr.
No, my lord,
I was not there for 10 days.
Yes, my lord,
That's why the list is running.
list is running, but we are not running. And because, my lord, our fixed matter is there.
So
Other
when you
things
can
are-
do this matter?
In any day, my lord, when your lordship, in next week or in any day?
Tomorrow?
No, tomorrow, I have no.
Tomorrow
My lord,
or day after tomorrow?
Next week, my lord, any day.
I
Next week,
usually
any day,
take
my
up
lord.
this matter on Thursday and Friday. You know that.
My lord had fixed
But
the
this matter, I fixed this matter.
I know very well what is the meaning of preemptory otherwise,
I understand.
but I am not ready.
You are not ready.
Yes, my
So
lord.
when you will be ready?
Next week, any day.
Not this
At
week.
any time. Yes, my lord. Today, this week, I am very busy, my lord. Only for that, it is not possible for me, my lord. Your lordship fix the matter at 10:30. I have no objection as our senior lawyer is there, my lord. So we have no objection. According to his, my lord, predicate.
You know that.
Only for that reason, my lord.
Only for that reason, I
At
fixed the matter
10:30, my
10:30.
lord. But due to some
No, are you ready to do the matter 10:30 next week?
Yes, my lord. Any day.
My lord, Mr. Mukhopadhyay is online, my lord.
Yes, Mr. Mukherjee is here now.
According to Lordship's convenience, Lord, according to Lordship.
Mr. Mukherjee, I was not there for last 10 days.
I know that, my Lord. I'm only
So for that reason, the list is running huge.
according to Lordship's convenience on any day in the morning next week. According to Lordship's.
Okay, okay. Very well. 6th of August, 10:30.
Today is 6th.
Today is 6th. Okay, 13th. 13th of August. 13th of August?
Yes, ma'am.
10:30?
Yes, ma'am. 10:30.
Okay. Please take down. Mr. Chandicharan De, learned AGP, appears on behalf of the state authority. Full stop. Mr. Shaktinath Mukherjee, learned senior counsel, appears virtually on behalf of the petitioner. Full stop. Next paragraph. Today is fixed for argument on behalf of the state authority. Full stop. Mr. De express his inability to argue this matter today and seeks accommodation to fix the matter in the next week. Having heard the learned counsel, let the matter appear in the list on 13th of August 2025 at 10:30.
Yes, ma'am.
State authority shall argue the matter on 10:30 in the urgent date.
Grateful, Your Lordship.
Okay. Thank you.
My lord, I beseech.
Number one.
My lord, I beseech your lordship, my lord. My lord, Mrs. Pal has just mentioned a matter of Jalpaiguri. Your lordship are directed to move it, but Jalpaiguri there is no bench. That's why, my lord, I am mentioning that matter. Otherwise, I would not have beseeched your lordship, my lord.
No, Mr. Agrawal,
My lord.
in two matters, it was argued before this court that the group 8 matters
My
which
lord.
signed to me
My
pertains to the Jalpaiguri circuit bench should have
My
been
lord.
there.
My lord, but there should have been bench. Bench is not there now.
Now bench is not there. Bench
No,
is
my lord.
From Monday. Monday.
from Monday. So what you
And
want?
that's why, my lord, I mentioned the matter before Justice Sen, and he told that since matter is only for 2 days today, you mentioned it before Justice Samanto on Wednesday. That's why.
So if you mention this matter before this court, it will regularly appearing Monday before the Jalpaiguri.
No, my lord, it will not. It will appear tomorrow for a lordship, my lord.
Now tomorrow it cannot be appear. Tomorrow group 1 matters are there.
My lord, that is it is Jalpaiguri matter. This is not group concern, my lord. Any matter what is the group 8 will be taken by lordship any day for the Jalpaiguri separate list, my lord. And separately for Jalpaiguri, your lordship is not taking group 1, group 8, anything.
I know that.
That's why, my lord, let it appear tomorrow. I am giving notice, and or Friday, any day, my lord.
No, you know the matter, group 8 matters I cannot take up tomorrow or day after tomorrow. It
No,
will
my lord,
appear on Monday.
My lord, that is for this. That is for Calcutta bench. But
Yes.
for Jalpaiguri bench, my lord, that is not restricted to 8 or 1.
No, Mr.
Jalpaiguri
Agrawal, no,
separate.
I was not there for last two weeks. So
My
I
lord,
have
I shall take 5 minutes only in removing this matter.
subject to fact that
Thank
you
you, my
have
lord.
served. There are certain set of advocates, state advocates in the Jalpaiguri. They are not appearing. They are objecting.
No,
That
madam,
we are
this
not
is
there.
state will appear tomorrow. State will appear. I ensure your lordship that state will appear tomorrow. Otherwise, I won't do it.
Very well. You mentioned tomorrow. Today I am not taking this matter.
May it please your lordship.
Tomorrow I
Lordship,
will.
I am
Tomorrow.
with a very unfortunate thing. My lord, it's a WPA 12514 of 2016 matter. The matter, it was mentioned twice and you were agreed, your lordship were agreed upon for release this case. Almost hearing was over before the Justice got an act. But for last 1 month, department is sending report that file is under search. Mr. Sengupta, the senior advocate, he filed with the register for reconstruction of the file. My lord, this is a matter pertaining to common people. Other side is two central governments. One central government, one state government parastatals. And the file is missing. Earlier also it was missing for 5 years. My lord, very unfortunate.
Group 1 matter.
Group 1 matter. My lord, please, you kindly
So
permit
what
us
you
to
want?
reconstruction. For permission for reconstruction of the file.
Have you filed any application for that?
Application before the register I filed.
List it first. List it first.
Malad, may I be permitted?
Give me the slip. What is the number?
Yes, I'm seeing. Otherwise, a permission may be given.
Give me the slip first.
Okay,
Let it be
lordship.
listed first.
Yes.
Malad, may I be
That I would have
permitted? Paid matters, not item number 161. But the respondent authorities are going to be filled up, not FPS vacancy, not petitioner was selected, preliminary was selected, he was called for personal interview. Now, they have submitted a report, inquiry report, that the land which the petitioner shop come go down Milot has selected, that land belongs to PWD. Milot, but the record shows that the land belongs to the petitioner.
Then how they are saying that this is PWD land?
Milot, that's why Milot, I have made representation Milot repeatedly. They did not Milot pay any heed Milot. That's why Milot.
What do you want?
Milot, Milot, Lordship, kindly hear this matter because otherwise this matter will be infructuous Milot. Because they're going to be filled up.
On Monday. Today I am not taking any act.
Okay, Milot.
Okay.
That item number 161. Milot, I'll serve.
On Monday. I will take up this matter on Monday.
Item number 62 and 72 have taken notice.
Well, I had few matters to mention, but I'll mention on Monday then.
62 and 70. Today I not.
Mr. Dhara, what do you want?
Can you make it not this? Today I am not being the dream. So I 62 and 70.
If not taken up today, it would appear on Monday. 67.
62, 72.
You are the petitioner?
Yes, madam.
62 and 72.
Yes.
Yes. Next, call the list. This has been stalled for 10 days. Okay. Muhammad Sirajuddin versus State of West Bengal. I am reading only the operative portions. Under the above observation, I find no justification to entertain the writ petition. The writ petition is disposed of. Interim order, if any, passed by this court during the pendency of the writ petition is hereby vacated. Respondent 9 may act upon the impugned notices by taking immediate possession over the land in dispute.
Grateful to your lordship. Very grateful to your lordship.
Grateful.
No, I just fell ill suddenly. This is the first time in my life I have take the medical leave for a long.
It is quite natural.
Yes, thank you. For the list.
Item number 2, I am for the petitioner. This is for extension of interim order. Interim order expire on 30 July.
May I file my affidavit, my lord?
Matter is running in the list.
One request, my lord, every time perhaps the matters have been mentioned, no notice has been served. When there is a clear indication in the lordship, please.
Serving the notice.
When that
Have you
matter has to be mentioned upon notice, my lord.
Mr. Dhara, sir.
I mean, আপনার কিছু করি না।
আগে স্যার করেছে
আর কি প্রমাণ মিলে করেছি।
ওই
Please take down.
বলেই নি আমার।
তাহলে এসব আমাকে বলবে না, আমাকে এসব বলবে না।
Mr. Tara, whether you will use the opposition, they have filed the opposition.
No, no, they seeking for extension of time for opposition.
No,
Time was expired. No, time was expired, man.
There was a
No, no.
direction to file it within 2 weeks, my lord.
I understand. The
But
affidavit
could
of opposition they have placed. Whether you will use the exception,
No, 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 no. I have not received it.
you have
They have refused.
No, no. Who refused?
আমাদের লোকই refuse
না,
করে। I have
তোমাকে-
clear instructions.
তোমাকে সব ভুলভাল ইনস্ট্রাকশন দেয়।
না, কিছু ভুলভাল দেয় না, সার্ভিস করতে গেছিল রিফিউজ করে।
okay. If not served, then you serve.
Well, I will serve it here and now only.
Okay, you serve.
এই তো আমাকে পাঠিয়ে দিয়েছে, নিয়ে নাও।
কিন্তু
করে নাও, হয়ে গেল। Well, I've served it, মানে লর্ডশিপ রেকর্ড
Very
it.
good. Very good.
রেকর্ডে
But my learned friend had indicated, my lord, that he had given notice at the time of mentioning, my lord. My lord, his email speaks otherwise. The above writ petition was mentioned before Honorable Justice Samanta on such and such for extension of the. But at the time of mentioning, a notice ought to be given. There's a clear indication.
matter
Your lordship
running in
read,
the
my
list. On 28th, I
Or
mentioned this
whenever
matter.
This has been
I
the
mentioned
practice
this
of
matter.
honorable court,
Your
my
lordship
lord.
directed the matter appear on 30. After that, court are not sitting. I give the notice.
Well, delayed, it's always been a
Happen,
practice,
it
my
is-
lord, upon
it is-
notice.
It is a practice. You have to
Or the
serve upon-
matter ought to be mentioned, my lord.
Yes. This is the general regular practice of this court. Very well. On the prayer of the learned counsel for the respondent authorities, the time to file the affidavit in opposition by the respondent be extended till today. Full stop. Affidavit in opposition filed on behalf of respondent number 1 to 4 be taken on record. Full stop. Copy served. Full stop. Petitioner is at leave to use exception if any.
Within 2 weeks.
2 weeks. Within 2 weeks. Let the matter appear in the list under the heading of hearing on 25th of August 2025 at 2 p.m.
At 2 p.m.
But I was only beseeching, my lord, if it can be taken up in the month of September. I tell your lordship the reason, but against the interim order passed by your lordship, my lord, we have assailed it before the appeal court.
Okay.
So it is likely to be heard anytime. It was heard before Justice Paul, my lord,
Yes.
and now it's going to be heard anytime.
Very well. So then 8th of September.
Very well, very well.
8th of September at 2 p.m. 8th of September at 2 p.m. Full stop. Next para. Learned counsel for the petitioner 6 for extension of interim order passed by this court on the earlier occasion. Having heard the learned counsel for the parties, also considering the submission of the learned counsel for the respondent authority that an appeal has already been preferred before the Honorable Division Bench against the interim order passed by this court. I think it appropriate to extend the interim order. Full stop. Next paragraph. Let the interim order passed by this court on the earlier occasion is further extended till 16th of September 2025.
Well, 30, kindly maybe 30 September. Man.
30 September holiday. 16th of September 2025 or until further, whichever is earlier. Puja will start.
Then, 26 September, I can mention if the matter taken up before the division bench, I can mention the matter again. 26 September, man.
I fixed the date on 8th.
Oh, man.
Okay, that's why I give you.
I'm sorry.
Obliged, my lord. The lordship is better with your
Now,
lordship. Now the weather is catching up.
Yes.
Everyone on the
the
other
weather is catching up.
It's a virus catch there.
Yes, and it's making everyone very weak.
Okay.
Obliged, my lord.
Okay, thank you. Next.
Oh, my lord, I'm appearing for the appellant. My lord, today is the date fixed for submission by the respondent.
Respondent perhaps concluded. Not concluded?
My lord, kindly go through the last date order.
Only the interim order was extended.
Only the interim order extended. but,
31st July was the date.
My lord.
So who is appearing for the respondent?
My lord, I'm led by Mr. Masud Karim. He is there in the Waqaf board. He's just coming shortly. I'm praying before your lordship for a short passover. We are prepared for the submission. A short passover.
Okay, this appeal, I am hearing this appeal for long.
My lord.
Yes.
Respondent has made a submission at least five times.
Whether they have concluded or not.
My lord,
They have not concluded. Then they have to conclude. Okay, pass it over. Call next matter.
On the way.
We are for the respondent number 3 petitioner.
My lord, I appear
Contempt
on,
application.
my lord, I appear on behalf of the appellant petitioners.
As per your
In
lord's
contempt number 612 of 2025. My lord, there are two contempt petitions have been filed. One has been filed by my learned friend, and another contempt application was filed by my client, my lord. My lord, in both the contempt application, my lord, first contempt application, lordship directed the police authority to make an inquiry, and the inquiry report has already been filed. And my lord, in
It
that
has seen
application,
that you have already violated the order.
my lord, I admit because a plastering work and my lord,
Last two occasions you have taken the unconditional apology to.
lordship,
to-
lordship, I tell,
Then again your client has
again,
doing
my
the
lord,
same thing.
only a plastering work, and my lord, taking the a room was constructed, taking the boundary wall, and my learned
What
friends,
prevented you to
lordship,
take a
lordship,
permission
lordship,
from this
lordship.
court?
Lordship. That is true, my lord.
Then-
Without taking the leave of the court, my lord, that was done. This is my lord, and my lord, in my application, my lord, my learned friend's client also made several construction work, and he has his client has already admitted
separate thoughts, my lord.
in my application.
Status quo was directed to be
Yes,
maintained
yes,
in respect of
in
only
respect-
one plot. At the instance of this petitioner, my lord,
and both the
status
parties were restrained.
order of status quo was passed by this honorable court at the instance of the present petitioner responding number 3.
No, kindly
Only.
have a look into the order.
Because we made an application that they are going to construct. Now, after my lord, filing and moving, and this honorable court holding that he committed contempt, thereafter they filed this application recently in 2025.
No.
Recently
Allegation,
they have filed.
allegation,
Order of status quo is there.
yes,
They are-
both
of you
both
have
the
violated
parties.
the order.
In respect of both the parties.
Two suits, one for declaration and eviction, another for partition. In declaration and eviction, only one plot is involved. That is my client's plot, that is respondent number 3's plot. 237 plot number, 12 decimals is involved. And other 45 decimals involved in respect of partition suit, 6 plots are there. There was no order for status quo to be
No.
maintained by the parties in respect
So
of those.
whether you have violated the
No,
order.
no.
Yes, both
Need-
the parties was
Yes, we need
restrained by
not.
the Honorable High Court.
We need not
Kindly have a look into the order.
violate the order.
The order
Because you are possessing other plots.
We are parties to the other plots. We are
In
partisan.
partition suit.
Since partisan suit, we are also have share, 1/3 share.
There are no such interim order in the partition suit.
No, in the plot number 237, my brother, cousin brother, forcibly started construction. We brought notice to the honorable court, and court took cognizance of it, and passed an order, interim order.
My lord, that application
My
was
lord,
already disposed of.
That application disposed of, but
Condoning the
they,
conduct of the
they
contempt.
several occasions
What
they are.
is the status of all the litigations?
My lord,
Appeal
is pending.
appeal is ready for hearing.
This
Now-
it is an appeal.
yes, my
appeal.
lord, second appeal.
Second
Two
appeal.
appeals, two analogously heard.
Second appeal in connection of eviction suit or
Yes.
petition suit.
Both
both the-
Both the appeals.
My lord,
both
from the trial court, both the cases were heard together.
Are you fighting with the contempt application?
Lordship, that is the truth.
But
That is
they
the
have
fact, my lord.
occupied.
Yes, let it be heard.
You have already violated the order.
Yes,
My lord,
237.
undertake that. Lordship, again
Kindly
I
see
am,
the police report, my
again I am tendering unqualified apology.
They-
my
they
lord.
are-
My lord,
My lord, they are so
because my lord,
My lord, they are
before this court.
they are so
because
reckless, my lord.
this
They
was
are
done
so
during the
reckless.
period of
They are now
COVID-19.
again. They are again trying to my lord,
This
commit
was-
further contempt.
This was done during the COVID-19, my lord. And for so in the order in the wake of COVID-19, there is no such order in the state. All disorder. That's why you have violated the order. During that period, my lord, my client could not approach before the court, my lord, for taking a leave for construction. Whatever maybe you have admitted that you have violated. And my lord, both the parties.
No.
Both the parties kindly have a look into the order.
We need not violate.
No.
Because
if my learned friend is
because we will
denies,
get
my
we
lord,
will
let
get 1/3 share.
my lord, let there be an inquiry by the police authority.
In
Again,
respect,
why shall we deal with the contempt application, not the main matter? That is true, my lord. Let it be heard. Be fixed for hearing. Lordship, let it be heard. Both the appeals be
Lordship,
Lordship.
hard, my lord.
Appearing all
And
the parties.
Lordship, contempt matter maybe, my lord.
Lordship.
What they have already
My lord, paper
committed
is
contempt, my lord, that will be taken into account at the time of final hearing, and if they are found that they
Lordship.
that will be demolished, my lord.
That's why I am going to pass the order.
Let it be
the matter
delisted for
be heard.
final hearing.
Contempt applications, two applications. Item number. My lord, my learned friend filed the 757 of 2024. Tell me item number. 42. 42 is the contempt applications filed by
the respondent number 3 petitioner.
Anjali Mondal. She is respondent number 3.
Yes, ma'am.
You filed the contempt
My
application. Wherein you have said that you have already violated and asked for unconditional apology. Lordship. This matter. Okay. And another matter, 757 of 2024, my lord, this was filed by my learned friend's client. Whether it is running in the CPAN, this is pending. Lordship is hearing this contempt application. Item number. 757 টা কোথায় আছে দেখো আমাদের ওই 7
our contempt application is 42. Their contempt application is 44.
CPN 612 of 2025. Your contempt. Lordship. Only these two contempts are running. Lordship. Before a lordship.
That is clearly afterthought. Their contempt
I will
application.
take up this matter at the time of final hearing.
My lord.
Please take down.
If it is found that they have violated,
I will take up this matter.
that will be demolished, my lord.
Not both,
Because
both also.
Entire plot is for me, declared.
Both also. I have heard. Item number 42 to 46. একদম order করো এটাই। Headline called CPAN 757 of 2024. This is an application for contempt filed by respondent number 3. It is the contention of the respondent number 3 that this court during the pendency of the instant second appeal and has passed an order of status quo. Full stop. The petitioner, no, appellant,
Anil Mondal.
Appellant has Anil Mondal filed the cross appeal. My client is the appellant. He filed the cross appeal. Your client is the appellant. Yes, and his client is the cross appellant. Stop. Your client is the appellant in SAT 1987 of 2007. Yes, my lord. 187 and 1988. 1987 and 1988. Appeal is 109 of 2008.
Yes.
Huh? No. 35 of 2008. COT. Court. Yes, my lord. So who filed the second appeal 109? My client. Your client. Your client filed
Anil
Mondal.
Two appeals. Two second appeals.
Yes. So you are the appellant in both the appeals. Yes, my lord. Appellant has intentionally and deliberately violated the order of status quo passed by this court. It is the further contention of the respondent number 3 that alleged contemptor had earlier also violated the order and made an unconditional apology before this court on the earlier occasion with a specific abamement that the with a specific abamement that the appellant shall not violate the order in future. But again, the appellant has violated the order.
Police
During
report
the
is there.
course of hearing,
Police report
this
is there.
court thought fit to call for a report from IC Falta PS in respect of the alleged violation of the order passed by this court. Full stop. The IC Falta PS has placed the report wherefrom it appears that actually the appellant has violated the order passed, violated the interim order passed by this court. On that, learned counsel for the appellant submits that his client was unaware about the matter, and during COVID pandemic, due to extreme urgency, he has made some construction. Full stop. As during that period, the court was not functioning properly, he could not appear before this court to seek leave. However, learned counsel for the appellant tender unconditional apology for his conduct. Considering the same, the unconditional apology extended by the appellant, alleged contender, stroke appellant, be recorded herein with a specific caution that if in future the petitioner stroke alleged contender appellant violate the order of this court, the appeal the appeal filed by the appellant shall be it shall affect the merit of the appeal filed by the appellant. Full stop. I make it clear that the appellant has deliberately violated the order on the earlier occasion as well as this occasion also. If in future he again violates the order, the second appeal will be dismissed automatically for disobedience of the order of this court. Full stop. Next para. Lekho. CPN 612 of 2025. Decision application for contempt by the appellant against respondent number 3 with the allegation that the respondent number 3 has violated the interim order of status quo passed by this court during the course of pendency of the instant appeal. Learned counsel for the respondent number 3 raised strong objection and submits that the respondent number 3 has not violated any order. Full stop. Next para. Having heard the learned counsel for the parties, and it appears that 2 appeals are pending before this court for disposal, being SAT 1987 of 2007 as well as 109 of 2008. SA code, SA 109 of 2008. Full stop. Against the appeal being SAT 1987 of 2007, there is a cross appeal being number COT 35 of 2008. Full stop. After filing of these appeals by the parties, at least 4 contempt application has been filed by both the parties. By 2 contempt applications by respective parties. Why 2 contempt? There are 2 contempt applications. 2 contempt applications. 2 respective contempt applications were filed by the parties. On earlier, there are some contempt applications.
Yes, first
There are earlier 3 applications.
total 3.
Total 3.
That is
there is 1-4 against them.
that is at the instance of the respondent number 3.
Okay.
Except 1.
Just right. 4 contempt applications are filed by the parties by the respective parties. It appears that the appeals are pending since 2007. Before dealing with the contempt application, it is required to take up these appeals. Full stop. The merit of contempt application being CPN 612 of 2025 will be considered at the time of final hearing of the appeals. Full stop. Let whether the paper books are ready.
Ready.
Everything is ready. Paper. I have been informed by the parties that learned counsel for the parties that the paper books are ready. Let the appeal be fixed for hearing. Let all the appeals being SAT 1987 of 2007, comma, Court 35 of 2008, and second appeal being numbers SA 109 of 2008 be fixed for hearing of appeal on 18th of August 2025.
August
18th of August 2025.
আচ্ছা 18th August may it be taken up at 2 p.m. তাই বলি
এখনই দিলাম Okay, 2 p.m. it will be second matter.
Lordship.
2 p.m. second matter.
And my lord, since the my application that is 612 is not decided by lordship now, then my lord, in the meantime, the police may be directed to make an inquiry in respect of my application.
No. Not that.
My lord, may I be permitted to file the opposition in respect of my learned friend's client's application, my lord. That is in respect of 757. My opposition may be taken on record.
Allow me to file reply.
Hey, take on. প্রথমে করে নেব ওই 757 এর 757 2000 পরে প্রথমে করে এফিডেভিট ইন অপোজিশন ফাইল অন বিহাফ অফ দ্য অ্যালিজড কন্টেম্প্ট
আচ্ছা রিপ্লাই আর
এটা কোথায় অরিজিনালটা কোথায়
What is this?
reply to the opposition.
Reply to the opposition filed by the respondent number 3.
আমার এটা
Be also taken on record. কি এগুলো?
ও অপশন দিয়ে দিন ঠিক আছে
হয়েছে এটা করে দেবে হ্যাঁ ওই কন্টেম্পট নাম্বার পিপি 757 অফ 2004 তে যে শেষ করেছিল পিপি 757 শেষ করলাম এখন শেষ করছি
নেই আমার কাছে
এখানে ডিসপ্লে
আমরা
তারপরে তো সিপিএন 612 শুরু করলাম 612 শুরু করলাম ওর আগেই করে দেবেন এই অ্যাপ্লিকেশনটা কোথায় ওর আগে করে দেবেন আমরা above observation contempt application being 757 of 2024 be disposed of অ্যাপ্লিকেশনটা কোথায়
এটা রিপ্লাই আমার অপোজিশন
ওকে নেক্সট
my lord I'm good to yours.
My application for contempt. Your lordship, order and page.
new contempt application.
Yes, madam.
Mr. Dhara, new contempt application. Yes, what is the matter?
At page 13 of your lordship order.
Page 13.
13.
Yes.
This matter regard to I have been suspended. I have been given reply. Hearing was take place.
Yes.
No order was passed.
Yes.
Then manner again minor suspension order was extended. Since then I filed the writ petition challenging the suspension order. Your lordship passed the order considering the division bench order. After 60 days, no suspension order can be extended. So I will stay the suspension order and directed to resume the supply. Order was passed on 2nd July, or order was communicated. Till date, no supply was started. Come to the page 17. Considering the same, I find merit in the instant petition, hence the interim order of suspension issued against the present petitioner dated such and such is hereby stayed for a period of 8 weeks from date. The authority concerned is consequent to order of the stay of the order to shall resume the supply of the commodity. No supply has been paid, no affidavit also filed. Therefore, I pay for rule, my lord.
Yes.
My lord, in this matter, item number 47, my lord, possibly this is the first time the matter is appearing, my lord. Mr. Nilotpal Chatterjee just received the instruction to appear, my lord. Let them serve, my lord, and allow us to come back. He has no copy, my lord. Let them serve, my lord, in the meantime. Allow us to come back after 3 or 4 weeks, my lord.
3 or 4 weeks, when I pay for rule, my lord, because till then no supply was started.
Maybe, my lord, but let the
Maybe,
copy be let the copy be served upon Mr. Chatterjee, my lord. Let him go through with the
Copy has to be served. That is,
Yes,
that
my
is
lord.
not the issue.
1 month gone, no supply was resumed. Now I take the time for 1 month again.
Very good. Please take down. Instant contempt application has been filed against the alleged contemners stroke government authorities for deliberate violation, for alleged deliberate violation of order of this court dated 2nd of July 2025. Mr. Dhada, learned counsel, Mr. Ramesh Dhada, learned counsel, appearing on behalf of the petitioner, submits that they have not preferred any appeal.
No.
That the respondent authority has not preferred the appeal, has not preferred any appeal against the order passed by this court, but they have not complied with the order wherein this court has directed the authorities to resume the supply of MR commodities to the FPS of the petitioner with immediate effect. Since then, since then, 1 month has already been elapsed. The authority concerned has not taken any steps. So he prayed for issuance of rule. Full stop. Having heard the learned having heard Mr. Dhara, it appears that there are substance to admit the instant contempt application. Let the contempt application be admitted. Full stop. The petitioner is directed to serve the contempt application upon the alleged contemptor. Let the matter appear in the list in the next week. That is on 13th of August 2025. Another same heading. Serve and come. Petitioner to file an affidavit of service on the returnable date. Next.
I am for the state, my lord. I am submitting my lord, report, my lord.
What is this matters? 11th. Okay.
I have just received the report.
Okay. Please take down. Report in the form of affidavit filed on behalf of the respondent number 1, 2, 3, and 4 be taken on record. Copy served. Full stop. Next para, copy served. Full stop. Next para, the petitioner is leave to use the exception against the report within a week. Let the matter appear in the list on 11th of August 2025.
That's it.
Another same heading.
Today is 6th. So if your lordship gives me
11th.
Lordship gives
As
me
I have fixed all the matters on 11th.
but if your lordship gives me a week's time to file my exception, my lord, that will cross 11.
2 days. Then not weeks. 2 days.
No. How can I? These people will have this is from.
Then use 2 days.
This is a
Similar matters are there, that's why I'm fixing the matters for him.
No, I believe, my lord, on 11, my lord, perhaps the matter cannot be, my lord, taken up. My lord, all the matters will not be able to take, my lord, because in all the matters, the state has yet not filed, my lord, their report. In most of the matters, my lord,
In the most of the matter, they have preferred.
most of the matters they have not.
How many matters are there, Mr. Huda?
Around 30, my lord, and they filed in around 10.
No, in the last Monday, they have filed only two reports. Today, they're supposed to file all the reports.
Let's see. 11, my lord, the chances are very bleak, my lord. I believe, my lord, on 11, the chances are really
Very well. The petitioner has a leave to use the reply, stroke exception against the report within 11th. Let it fix on 11th.
Practically impossible.
I understand it
People are from Murshidabad, so they will not.
I understand it is impossible. I am fixing the matter so that all matters can be.
No, because that will again will show a default on my part that I have not been able to file my exception.
You take a leave.
But it keeps it after 11, not a problem, my lord. Same order would follow.
No. You let it be kept on 11. You submit that it is not ready. I will pass the order.
That would be, my lord, that would have, my lord, a negative repercussion, my lord. Because I will
Why
come
negative?
and say, because I will come and say, my lord, I'll be praying for time for extension, my lord. That will.
I want to fix all the matters
I
altogether.
understand, Lord. I understand, Lord. But it is practically impossible, my lord, for a person, my lord, to come from Murshidabad, my lord, within 2 days. Because I just have, my lord, Thursday and Friday.
Murshidabad in a bus only one night journey.
I do not even know, my lord, if there's some difficulty or not.
You cannot say the journey like that.
Kindly fix it, my lord, after a week, my lord. 11th. Kindly fix it on 18th then.
18th. Within a week. 18th of August.
Yes. Well, my lord, because again, it will not look good in the order, my lord, that I have been praying for time. And I usually try not to do that.
Very good. Next.
The state is supposed to file the report.
Mr. Wasim Ahmed. Same report.
Yes. Chief keeps it on 18th only then.
None appears on behalf of the state. Let the matter appear in the list on 18th of August 2025 under the same heading.
In the meantime, report to be filed.
State is a leave to use the report, file the report in the meantime. Next.
If he say, my lord, state is supposed to file report.
Mr. Amrudulal Chatterjee and Nilotpal Chatterjee, where are they? Similar order. Next.
I am for the private rest.
My lord, I am for the petitioner in this matter, my lord. Mr. Mrityunjay Saha is appearing for the, he is the advocate on record in this matter, my lord. He is not well, my lord. I am only praying for not today, my lord. I'll come tomorrow, my lord.
Tomorrow I don't have the details.
My lord, then Monday, my lord. Let it be not today, my lord. It will be.
Matter. Whether I have heard the matter.
Possibly
Yes,
they will
yes.
not proceed with the matter as I understood. A report has been submitted, where from it appears is area of shop room is 87 square feet.
Okay, whether you have placed the report.
Yes. In the it appears from their report, my lord.
Okay. Very well, not today. Come on Monday.
Deeply obliged, my lord.
They have not filed any exception. I think they have nothing to say.
Next.
Let the matter be called.
Be called. The 52, my lord, appeal for the petitioner, my lord. But,
You have received?
comprehensive report, sir. That I have received the report.
Wait.
With Mrs. Sinha, my lord, there is no difficulty.
I am so grateful for such kind words.
She ensures that the report is filed.
Please take down comprehensive report in the form of affidavit on behalf of the state respondent be taken on record. Next para copy sir. Petitioner is at leave to use exception against the report within a week. Let the matter appear in the list on 18th. 18th of August under the same head.
Obliged.
Next.
53 I appear for the petitioner. The state is supposed to file the report.
Mr. Suman Sengupta. Roipan Basu Moldik.
Same order, my lord. 18th.
Similar order on 18th.
Similar order as in item number 50.
Next.
I appear for the petitioner, my lord.
Similar order fixed on 18th. Next. New matter, who is appearing? Not today. Next.
Well, item number 56, I am appearing, my lord.
Item 54, my lord, I am.
56.
56, my lord.
54, I am for this state, my lord.
54.
Yes, my lord. There is a direction for affidavit, my lord. This. May I?
Affidavit ready?
Yes, yes. May I file, my lord?
Serve a copy?
Already served. Masud, দেখা উচিত
Just wait, Mr. Agarwal.
My lord, my lord.
আপনাকে খবর থাকে না জুনিয়র বলেনি
Copy served. Copy served.
হ্যাঁ ওই অর্ডারটা করো
আরে উপর থেকে দৌড়াতে দৌড়াতে
হ্যাঁ জানিস exception within a week it will appear on 18th. 18th.
Grateful, my lord.
Yes, call 56.
56
and 57.
My lord, in item number 56, state was directed to submit a report that has not been submitted.
Your Lordship, I don't think my learned junior is not present. I don't think I have not received a copy on her behalf. Otherwise, I would have done it. Though I have received the instructions. If you want, I can argue on the basis of this.
There is no question because the similar matters are fixed on 11th or 18th.
Yes.
Let it be fixed on 11th. Okay.
My lord.
Okay. Let the matter be appear in the list on 11th.
11th.
But in the meantime, if they want to file, they should file the report.
11th of August 2025. Full stop. Today, petitioner, state authority is supposed to file a report. Mr. Sonal Sinha, learned AGP, submits that.
There is a request on behalf of Mr. ঠিক আছে
The report may be ready, but it is not handy with her to file the report before the
देखो इसमें क्या करना है
state authority. We at liberty to file the report within the meantime.
Well, deeply outlined.
Applying a copy to the learned counsel for the petitioner.
Deeply obliged, my lord.
তুমি আছো 11th আসবে ঠিক আছে next 58 64
Timir Baron Shah is appearing on behalf of the petitioner.
yes
I am praying only not today.
not today new matter
Yes, new matter. I have received
Because
the
due
instruction.
to some
let it
personal
appear on Monday
Monday, as your lordship. Great.
তুলসী নাম দিয়ে দাও, নাম দিয়ে দাও। ওনার কেউ আসবে না, আমি শুধু নামটা দিই।
next
15 ml, I am appealing for the state, my lord. New matter.
let me see what is there
Nobody is for the petition.
not today next
My lord, advocate Anona Niyogi is appearing for the state.
you are appearing for
the state, my lord. Anona Niyogi is appearing for the state, my lord. She could not be here for personal reason. I'm praying for not today, my lord.
not today
Grateful, my lord.
Supplementary.
For supplementary টা file করা হয়নি কি exception দিবি টা but I appear on behalf of the state, my lord. May I file my supplementary report, my lord, which was directed
The last token lordship directed my lord this state to file a supplementary report, my lord, disclosing certain documents, my lord.
the inquiry report of the
I have
SCSS and
received a copy, my lord. Lordship kindly takes it up, my lord, after a week.
you want to use exception against the report
The report is entirely in my favor, my lord. Lordship,
Yes.
please, my lord, I had got
Okay,
58, my
okay,
lord, so perhaps, my lord, may not be required. And if, my lord, I file, my lord, I'll do it within a week, my lord, within 2 days, I'll do it.
supplementary report in the form of affidavit file on behalf of the state respondent be taken on record
আমি বেশি মার্কস পেয়েছি
let the matter appear
পরে কি
হ্যাঁ পরে কি
on
যা
18th of
পরিষ্কার সেটা বলো
August 2025
মানে হচ্ছে কোনো আমাদের ইয়ে নেই
petitioner is at leave to use exception comma if any within the meantime
15 তারিখে ওই উইকটা রাখ না 15 তারিখে পরের উইকটা রাখ না
18 তারিখে তো রেখেছে
18 তারিখে
next
grateful lordship ওটা kept with the record করেছেন
not today
kept with the record
not today Mr. Dhara has taken leave
মিস্টার ধারা
কত গো
62 and 72 both matters
Then can I just file this because there was a direction to file the affidavit in opposition. That is just be taken on record.
Mr. Dhara is not
So then they have given us a reply also. Which they
so
have.
Mr. Dhara has to be there otherwise I cannot take away your matter in the morning he has taken leave to for 62 and 72 two matters
We're not
come on Monday you keep it yourself next 63
Appearing. Kindly make it not today.
not today
Great.
3.
My lord, 64, Mr. Sonagos appearing in all virtually, my lord.
who is appearing in the virtual mode
Sonag Ghosh.
where is Mr. Bose
Might be a network issue.
what is the matter
I don't award this matter, my lord.
no one is appearing not to give effect in the order dated 8th May
Delay anymore to issue the license as the petition is ready in petitioner is ready in all aspects to operate the FPS as per the terms of the license.
what is the order dated 8th May
8th May order. The impugned order.
okay is in order Non-fulfillment of a financial solvency criteria.
I can see page number 21, your lordship kindly comes to.
Page 86.
Page 86.
Of the writ petition.
Lordship, is this 15883 of 2020?
No.
13915.
13915.
Yes. Peter, wrong, Lordship.
Mr. Sinha, you are not there.
I think I'm not there.
Okay, no one is there. Not today.
Madam.
65. I am for the petitioner. I am paying for not today.
Not today.
Yes.
Then come on Monday. Mr. Dattu, you are there.
Yes, sir.
Actually, she is engaged in the next court, my learned advocate.
So you are not ready today or not want to do this matter today before this court. Whatever maybe come on Monday then.
The show cause has been questioned after giving reply.
Show cause.
Show cause has been questioned after giving reply.
After giving reply
Yes.
to the show cause.
Yes. It's totally premature.
Very good. Next.
As well as 66, I am paying for not today.
I am taking notes, my lordship.
Under the state. Also there.
I am paying for not today. I am for petitioner 6466 item.
You are running with the license? Then you run with the license. Okay, let run with the license. Come on Monday then.
My lord.
67. Lordship, I am for the minute, petitioner minute. Pillar, I filed the abuse service. And Lordship.
What is this? Item number? Item number 67.
67. And Lordship, I filed the abuse service, Lordship. And Lordship, I am
Which for the state?
Milan, I am given the notice minute earlier.
Respondent number 5.
Private respondent. Private respondent.
And Lordship, allow me to file the Milan
Supplementary affidavit.
Yes, sir. In connection of this petition.
Have you served the copy to other parties?
Without them allow
I have
how to be the
supplementary copy of supplementary.
Milan, I am
My lord, it is a very
just now.
just do it.
What is the necessary to file supplementary? What is the matter about?
Minute.
My lord,
This is the very
Just do it. I am not asking you.
very quick minute. Lordship, advertisement was made. Subsequently, Miller advised, I applied. Also, Miller others.
Advertisement dated 28th June.
Lordship.
Yes.
And Lordship kindly see.
You applied for the license.
After that Miller, the Miller instruction was made with videography. With videography, Miller. I am the best candidate at the time of the Miller inquiry. On that time, Miller, because my godown is big, other than, and also that just there is points of this Miller location. Miller, just on second Miller, July Miller.
Take the mic. This mic. You take this mic. You take this mic.
I came to know Lordship. Already the name was selected in the name of the respondent 5. That is Vilkis. Miller, Lordship kindly gone through the Miller supplementary bit. Supplementary Lordship kindly see the very peculiar things, Lordship. Lordship, the deed P5. Hevanaman Dolil submitted on 2nd September 2024 and the registration was completed on Lordship kindly come to the minute last page of the registration. Yes, page 17 of the Miller on Lordship can see when the book number 1 on such and such on 13/5/2024 27. This is well. Milord, after onwards, Milord. In the meantime, what's happened, Lordship? Before that registration, already, Milord, I came to know the name was recorded in the name of the respondent file. 18, page 18. On 27/8/24. Lordship got it? How it is possible, Milord? Before the registration and after 12 days, Milord, within 12 days, the Milord advisement would base and file the Milord application. Within 12 days, how to, Milord, obtain the order of the Panchayat for building and how to construct the building and, Milord, how to, Milord, complete all these things. And, Milord, it is possible that before the registration, the Milord mutation has been made. And also, I came to know, Milord, I have not filed. The copy handed over to me, my client. That very particular portion of the deed is vague because against that, the case is pending before the Rampur Civil Court. In case number, Lordship, 128 of 2016 by the one Enal Haq versus Shamsuddin Sheikh regarding this plot. But it is possible, blood. All are manufactured, all are illegality has been done. And videography, Lordship, already at the time of the.
Who are you? You are one of the applicant. You are saying you are the most suitable candidate.
Milord, yes, I am the candidate, Lordship.
So,
the candidate.
So what you want today?
Milord, already, Milord, offer letter has been given, and the loan allotment has been given. Though the, Milord, all equipments has been sent in the name of the respondent 5, till date no allotment has been given.
So you serve the copy upon the
I give you the copy, Lordship.
No, upon the state authority.
Supplementary to the respondent 5.
No supplementary.
Supplementary affidavit.
Just writ petition. Copy of the writ petition has been submitted.
Please take down. Supplementary affidavit file petition taken on record. Petitioner is leave to use supplementary affidavit in connection with the writ petition. Let the supplementary affidavit be served upon the private respondent as well as the state respondent within a week. Petitioner let the matter appear in the list under the same heading on 19th of August 2025 under the same heading. The petitioner to file an affidavit of service on the urgent date. Come on 19th.
Milord, state also, Milord, Lordship.
Who is appearing for the state?
My lord, so learned advocate Suman Sengupta, my lord, he is on his way.
You serve a copy.
Yes, Lordship, Milord, Lordship, kindly allow the stay, Milord, for the time being. Let them file the Milord all records.
No, without perusing the report, I cannot file the pass any order.
Number 5, my lord, 2 persons applied for the state post according to the advertisement, and the concerned respondent.
That means you are the petitioner. You and the petitioner.
Yes.
2 person means you and the petitioner.
Yeah, and me and the petitioner, and I have supplied for the application form and the registered deed also. All accommodation supplied. Concerned respondent inquired the place. Everything.
Okay, come on 19th. I will take up this matter on the in presence of 19th is the date.
And the concerned respondent granted me for license. Now this writ petition has been filed.
Possible, Milord. This deed is.
Okay, I will take up this matter on report.
Lordship, in the meantime, Milord, stop the Milord allotment.
No.
Milord, if the allotment.
Please take down.
Hey,
Milord,
Milord, please the date, any date.
State is directed to submit a report on the urgent date. Submit a short report on the urgent date.
With videography, Milord. With videography. With videography.
Videography is not required. The report is exhaustive. It
And
will
Lordship,
all the points.
Lordship also considered, Lordship, the Milord supplementary writ, which was Milord filed before Lordship.
I have also taken up the supplementary.
Milord, in the meantime, Lordship.
You serve the supplementary?
Already served.
Okay.
Already served. Lordship kindly stop the field, only buying.
If there is an illegality, the offer letter can be cancelled, right out.
Lordship, I'm giving you all these things,
No,
illegality has been done.
No, report has to be taken up. Otherwise, your matter cannot be.
The report has come, report
Within the adjourned report has to be submitted on 19th.
Lordship, on
19th.
19th August.
19th of August.
19th August, Lordship, kindly, Lordship, kindly status quo, Lordship.
No.
Lordship.
No.
Lordship, status quo, Lordship.
I'm praying for only not today, my lord.
Generally not pass any status quo without report.
My lord, 68, I'm praying for not today.
No. Yes. No, sir. Without report, I cannot pass status quo.
68, not today, my lord. I'm praying for only not today, my lord.
69.
69, I'm for the petition.
Who is appearing for the petitioner?
I'm for the petition, 69.
68, I'm for the petition.
68. Yes.
I'm praying for only not today, my lord.
Not today.
The number. 69, I'm for the petitioner. No. But this is the affidavit of service. Yes, repeat to them.
Mr. Shivsanu Bandyopadhyay, Mr. Tapati Samanto.
So far, private respondent is concerned.
Have you served?
I have served. The envelope has returned back.
Returned back.
Returned back.
What is the intimation? What is the intimation there?
Insufficient address.
Then you have to
Now
serve.
you'll have to kindly see. That's why I'm saying that. You'll have to kindly see the deed, the address of the private respondent. In the deed and what address I have sent are same. The front page of the deed. What is the address, my lord? And so far,
Insufficient address.
it is mentioned, and you'll also kindly see the name of the private respondent is Mohammad Somir Hossain, Jodhpur, Komlabadi, PS English Bazaar, District Malda. Same address. There is no difference.
You try again and come.
My lord, I am appearing on behalf of state. That if your lordship direct us to file a report, you can file a report.
Within a week?
No, we did not give some more time, my lord.
There are some urgencies involved. A private respondent who has been offer letter, in whose paper offer letter has been issued, he is not an eligible candidate.
So you have to serve upon him.
But I cannot serve. Whatever the address I have served. In the deed, what is the address I have served?
Your client must have known what.
My client has given me the same address, in which I have in the costacle that has been mentioned.
Whatever maybe, you have to try again.
I can try again, my lord.
Without service, how can I?
That I can try again once again. But if in the meantime license has been issued, then this will be a difficulty for me, for the petitioner.
Till today, they have not issued any license. You have filed it in the year.
This year also I have filed. I have filed
My lord,
4th of July.
30th June.
30th June.
30th June 2025. Affirm on 30th June.
June. Kina?
Okay. Please take down. You serve again. Learned counsel for the petitioner submits that service upon the private. No. Submits that the private respondent is residing in the address given in the petition, but on service of the registered consignment. No. But service upon the private respondent was written with a intimation that insufficient address. Intimation, comma diye lekho, comma quote karo. Insufficient address. Unquote. The Bhattacharya, learned counsel for the petitioner, submits that the petitioner intentionally trying to evade the process of this court.
Petitioner, private respondent.
Private respondent. Private respondent intentionally trying to evade the process of this court. State is represented through learned counsel Mr. Shirshana Bandyopadhyay with Mrs. Tapati Samarthi. It appears that the offer letter issued in favor of the private respondent is under challenge before this court. On that situation, the private respondent must have been served before passing any order. Accordingly, petitioner is further directed to serve again upon the private respondent.
But I will serve the private. But I will serve. May I request my learned friend to intimate the private respondent since they are the sub-judicial counselor may intimate
Yes.
My learned friend's client if intimate the same to the private respondent. He knows
Private respondent, full stop. Okay. As the state authority is appearing before this court, it is opportunity for this court to direct the state authority to inform the private respondent in favor of whom they have already issued an offer letter. State is further next paragraph. State is further directed to submit a short report in respect of the writ petition in the adjournment. This is the matter again on 19th of August. 19th or 20th.
They have issued the offer letter. If the license issued, then my lord.
You have already made him party.
I have made him party.
Then what is the difficulty?
I'm deeply obliged, madam. 19th.
And affidavit service we kept with the record.
এই সার্ভিসটা দিয়ে দাও এটা মনে হয় affidavit of service filed on behalf of the petitioner is taken out.
I'm deeply obliged.
But that has to be kept on record. Insufficient. That has to be kept on record. This one.
Okay, you want this? Okay.
No, I don't want it. This has to be kept on record.
Okay.
Kept with the record.
My lord, I'm praying for short passover. Mr. Shami Mulbari engaged in court number 8. I'm praying for short passover, my lord.
At the 12, you want Passover?
No, it is item 70.
70.
Yes.
You are for the
Petitioner. Mr. Shami Mulbari appear for the petitioner.
But I
take
appear
the
for,
mic. I cannot hear you.
but I appear for the state.
You are praying for the state.
I'm praying for
Praying for what?
not today.
Not today. Then come on Monday. Okay. Very well. Not today.
Item 42 টা কি হয়েছে?
In item number 71, Lordship, I beg to appear on behalf of the petitioner, Lordship. In earlier occasion, Lordship, this respondent number 5 has served a copy of the report. And so far, the order of 28th July's concern, Lordship has directed us, grant us leave to take the exception to the report, Lordship. I am filing a report today, Lordship, exception to the report, and it's already served upon the state respondent, Lordship. Now, the fact remains, Lordship, that the person who has been awarded with the license, Lordship, must be added as a party in this writ petition for further, Lordship. So, leave may be granted to add him as a respondent, added respondent, and served upon them, and then after, Lordship, kindly fix a time for hearing, Lordship. I take all the exception, Lordship.
Who is the answering respondent? State
Answering
authority.
is the state.
Answering
They
respondent.
have submitted the report.
They have submitted the report,
Lordship kindly comes to the exception. He has filed paragraph 14.
Give me the exception. Whether you have filed the exception today?
Lordship.
Paragraph 14, Lordship kindly comes once. Petitioner is giving marks to himself.
No, I have calculated myself, Lordship. It's my marks will be 71 if it properly calculated. That is my submission, Lordship. And I have taken all the exception that how the marks has been awarded to the respondent to whom, Lordship, the license has been awarded.
And then after Lordship, I have annexed the document relying upon which the marks has been calculated, Lordship, that the particular notification, the breakup of the marks has been specifically stated that in which category the number will be awarded, in which category and how much number will be calculated. Now, Lordship, I have come to the each and every document, Lordship. Kindly come to my
Purely
first.
an administrative decision, Lordship.
How
Notice
can
that
be
there is-
administrative decision when there is a gross irregularities, Lordship?
Even that
I am
is there.
pointing out the gross
Petitioner doesn't have
irregularities.
any remedy
Let
before
me hear,
Yes, your Lordship.
let me hear out the
Yes,
petitioner
your Lordship.
first.
Now, Lordship,
Yes.
kindly come to Lordship, Annexure A, Lordship, that is page 11, Lordship. Lordship will kindly take the report first, Lordship. That report has been filed by the state respondent, Lordship.
Yes.
That report speaks itself, Lordship, that the report which has been annexed as P1, Lordship, that is not paginated, but your Lordship will come to the report which has been annexed, Lordship, within the report, Lordship, as P1, Lordship will find that that the person who was selected as a most eligible candidate, Lordship, his name is transparent from the very beginning of the page, Lordship. That is under vacancy number such and such, application number such and such, date of inquiry conducted on 29/10/2024. And the person,
9, serial number 9.
serial number 9, kind to come to serial number 9, Lordship, that the Samad Sheikh is the person in favor of whom, Lordship, the license has been issued. Now, Lordship, kindly come to the very next page, Lordship. Lordship will find that.
Reading page.
Lordship, kindly come to the column number 52, Lordship, at once. Column number 52, Lordship, serial number 52. Part 4, Lordship, that the storage go down and official details.
Page 10, he is referring to. I
Page,
think.
page marks আমার সাথে করা ছিল না কপিটা
তুমি
তো
করোনি তাহলে page।
ওটা নিজে না ওতেও করা নেই হয়তো Now, Lordship will find from the column number 52, there is 2 points. One is go down with separate office space. Now, it has been mentioned that Dag number.
Just wait.
Lordship.
What are you saying? Let me follow your submission.
Yes, your Lordship.
So you are saying about the report of Firoja Parveen.
No, no, Lordship. I am saying that the person who has been selected by the state respondent,
Kindly
Lordship.
takes my report.
Samsad Sheikh.
Yes, Lordship. Yes.
Samad Sheikh.
Samad Sheikh, Lordship.
Yes.
Samad Sheikh, Lordship, has kindly come to column number 52 of the report, Lordship.
Column number 52.
Lordship kindly comes to
52.
page number 10.
10.
That's just page number 10.
Yes.
This is column.
Yes, your Lordship.
Serial number 52.
So
Lordship, now what is the specification that the go down with separate office space? Full address of the shopcom go down with Dag number, Khotian number, such and such, such and such. Now come to the right side, Lordship, that Dag number 510, Khotian number 2827, Lordship. Lordship has got it, the Khotian
yes,
number.
proceed.
Yes, your Lordship. Now 2827 is the Khotian number which belongs to the person to whom the license has been awarded. Now, Lordship, kindly come to my report, Lordship, my exception, Lordship. Lordship will find from page number 12, page number 13, Lordship. Page number 13 of my report, Lordship, of my exception, Lordship. I have annexed the document which is obtained from the official website of the Banglar Bhumi, maintained by the government of West Bengal. That the reflection of Khotian number 2827, which has been mentioned, Lordship. So, my Lord, 2827 is the Khotian number where it has been stated, Lordship, that the Khotian was generated on 21st/12/2020. It's a Rayatto Sampatti, Lordship. Its property belongs to the person upon whom that Khotian has been awarded. Now, Lordship, is the in that Dag number, Lordship, that the Poriman has been measured at 0.0099. If your Lordship is calculate the upon the share of the property,
that is share.
Yes, your Lordship. Share is 0.0549.
No.
If Lordship calculate, then Lordship, it will come that the property which has been shown, that is 405 square feet only.
So whether you are there as a riot of the
No. I am not saying that,
so
Lordship.
what are you doing?
Now, Lordship, so far the report is concerned, I am challenging the report. So far the report is concerned, there has been measurement has been given that there is a compartment, Lordship will come to the B, that in case of multiple compartments, size of the sub-counter office area, such and such, Lordship. Now, it has been calculated that in that particular property, there is total 305 square feet of godown has been shown, and 154 square feet of office has been shown. If it aggregate lordship, it will come 454 square feet.
Yes.
So now the construction have to do the construction of 454 square feet. The land will be more than 454 square feet. Now, so far the reflection of document is concerned, this property which has been shown, that is less than 450. It is 405 square feet only. So whether this measurement has been perfectly measured or not, that is my question, Lordship.
That is not the question in the writ court. That is
Lordship,
writ court has
when
not-
this has been
No,
disclosed by them by
no,
filing
no,
a report,
Just wait.
Lordship.
In the record, there may be a zero.
Lordship.
There may be zero.
Yes, your Lordship. So I am calculating.
So you should not be bank upon that.
No, yes, Lordship. I am
Should not
coming
be
on
bank
that.
up. That is
Lordship.
not the good
So
ground.
far
So what
the-
is another ground?
That is one ground, Lordship.
Yes.
That they shown the land of 405 square feet. Upon which
understand
the
your submission.
construction
Next.
has shown as 454
Okay,
square
okay,
feet.
I understand your submission.
Now,
Next.
Lordship, kindly come to distance point. That is on 67, Lordship.
67.
On the very next page, Lordship.
Yes.
That the distance which has been measured, that is wrongly measured, and saying that its distance from the central location at 675 meter. Now, Lordship, we will come to my report, Lordship. My exception, Lordship, will find there is a category for the award of marks from separate measurement, Lordship. If your Lordship will come to the page number 15 onwards, Lordship will find that there is a specification that how the distance will be calculated and how marks will be awarded in case of the different distance.
Show me the page.
Lordship will find from page number 17. Name of the possession, size of the godown. It is the size of the godown has separated that with separate office space. It will be awarded with 10 marks. And if it's such and such 276 square feet, it will be 7 marks. There is a specification, Lordship, and Lordship will find that
Which portion?
He is referring to page number 17, serial number 567, I think.
Lordship.
I think.
What is the
Whatever.
size of the godown, I think.
And size of the godown and the distance is also there, Lordship.
Where is the distance?
Distance is also Lordship, I will come into that, Lordship. But and another point is that, Lordship,
Yes, next
kindly
point.
come to page number 18, Lordship.
Page number
18.
18.
18, Lordship.
Yes.
Serial number 12, Lordship. There is a two category. The delivery truck can be reached to the godown for uploading. That will be awarded with 5 marks. And accessible by small cart
that
for
will be awarded with
uploading. That is 2.
Yes.
2 marks will be awarded, Lordship. Now, Lordship, kindly come to my report, Lordship. I have annexed the document, Lordship, 2 photographs. Lordship, one is I got it from the from the report, Lordship. Kindly come to page number 19, Lordship.
Of the report.
From Annexure C, from the exception, Lordship. Page number 19.
19.
19.
What is this?
That is the sketch map.
Your measurement.
That is, it is measurement of Samat Sheikh. In my exception, Lordship, kindly come to page 19 of my exception. That has been prepared by the inquiry officer, that is Tomal Sil. Lordship has find the document.
Yes.
Now, Lordship, the approach road which has been shown, Lordship, it is connected to the main road. So far, the godown is concerned, which has been shown in the map, Lordship. The approach road, the measurement of the approach road has not been mentioned here. But, Lordship, that drawing is showing that, Lordship, it is connected to the main road.
So
Now,
what does it mean?
Now, Lordship, kindly come to my Lordship. On the very next page, Lordship. My godown is situated absolutely on the main road. That is the PWD road, Lordship. On the very next page, Lordship. Now, if it is properly calculated and properly marks has been awarded, Lordship, then this person will get 2 and I will get 5.
So what is the marks?
Marks has been awarded, Lordship, 5.
In both the cases?
No. In my case, marks has been awarded as 2. But in the case of the person to whom this license has been awarded, Lordship, he is awarded with the 5 marks.
column number.
Lordship, kindly come to
কোথায় 2 আর 5?
after the calculation, Lordship, I have got this, and another point, Lordship.
Where is the column?
তুমি যে টোটাল মার্কসটা দিয়েছো তাকে
টোটাল মার্কস তুমি ডিভিশনটা করছো কি করে?
প্রথম এই যে রেকমেন্ডেড 6 সামার
আরে রেকমেন্ডেডটা তো
I have awarded with the 2 and he has awarded with the 5, Lordship. Now, Lordship, kindly come to another point, that is on 60. Point number 60 to the report, Lordship. Point number 60, Lordship.
Point number
60.
কার ওরি?
Report. From the report, Lordship. From the report, kindly come to point number 60, Lordship.
Yes.
Lordship, that the plinth height of each go down from the road level and the ground level, that is measured at 1.25 feet.
কার এটা তোমারটা?
না না তোমার, তুমি যাকে দিয়েছো তার থামস আপ।
আচ্ছা একটু বুঝতে পারছি না। আমাদের তো
60 1.16
1.16.
Now come to the Lordship, the sketch map.
Yes.
Lordship, in the sketch map, it has shown.
স্কেচ ম্যাপটা কোথায় জানেন? এটা আমার
Yes.
স্কেচ ম্যাপটা তোমার রিপোর্টে আছে?
আমার রিপোর্ট তোমার থেকে
It is also in your report.
It is also in my report also, Lordship.
Page
19, page 19.
13, 1-3 of report.
Hmm.
Yes.
It has shown, Lordship,
1.2.
1.2.
Then what happened?
Now, Lordship, there is a discrepancy when it was recorded in the report, and so far the document is concerned, there is a discrepancy, Lordship. That the two are different. So, if I...
So what is the requirement?
Requirement is different, Lordship, but requirement is different, Lordship, but it transferred from the record that there is such discrepancy, Lordship.
These type of objections cannot be entertained.
Now, Lordship, kindly come to my first objection, that is the go down, Lordship, I have mentioned. So now, Lordship, so far my report is, my reply is concerned, I have mentioned each and everything, Lordship. Lordship, will kindly come to the photographs, Lordship. That is in page 11, Lordship. That the house has been shown as a go down.
We don't know if it is a photograph of that house or not. Then
that he can question.
Tell that.
Yes, so that's why I am on the very beginning. I have submitted, Lordship. The persuaded respondent has to answer, Lordship. Liberty may be given to Adam as a party, Lordship. Let him have answered and the question that whether
you have not raised any question.
Lordship, each and every question, Lordship, so far the record of rights is concerned, Lordship.
Nothing.
They have submitted a document, Lordship, whether shows that the property is only 400 square feet.
Writ court is not do these matters as appellate authority of the decision. Unless you have shown there is an arbitrary decision.
So arbitrary decision I'm showing, Lordship.
What is the
consider, Lordship, that so far the go down has been shown is concerned, Lordship, that the property is shown is concerned, Lordship. That is absolutely against the pro forma which has been prescribed by the vacancy.
No.
Lordship, kindly consider that one aspect, Lordship, that the record of right which has been shown, it has been specifically stated that
record of right may show the share 0. But
no, I am not asking the 0, Lordship.
No, that is not the question. There may be some arrangement between the parties. This is the joint property. So you are not the owner of the joint
property. That should be transferred.
You have no objection.
That should be transferred from the
no.
No, that must be transferred from the report, Lordship. That so far that's why I indicate, Lordship.
Very good.
So far the report is concerned, there is only one Pothian is mentioned. If someone he obtained a NOC from someone, that should be reflected from the report. That if owner is supported him by giving
you. Who are you to object?
Lordship, that I am
not
eligible
candidate.
My candidature has not been considered, and a person who has been considered, Lordship, that having always qualification.
Any point?
Another is that
this court there is some arbitrariness.
Yes, your lordship, that the go down is the principal thing, lordship.
No,
If someone has no go down,
Mr.
if he
Karaja,
show
you know that is not
no
the
lordship,
good
if someone has no go down, he's showing his
This
house
is
as a
not
go
the
down,
good- this is
and
not-
then after lordship, lordship, then I will.
If you can show that he
Lordship.
has no land there, then I can understand.
But the measurement is land also be taken into
Measurement
consideration.
cannot be taken on the basis of the LR report or any
Lordship,
record
then
of
only one liberty I am asking, lordship. Then the matter may be not today, lordship.
No,
I will
not
come back
today.
because
No,
one
no.
document is there, lordship. I can show one thing, lordship. Kindly come, lordship. That he have mentioned the deed number, lordship. Kindly come to the
Lordship,
70,
even
column
if we
71, lordship. May I? Column 71, lordship. Kindly come to column 71. The registration deed is mentioned in the report, lordship. So when I've searched the registration deed, lordship, it can be obtained certified copy. So lordship, let me 1 week time be given that I will come up with the registration deed, lordship. That
What is
it will
requirement
show
of registration deed?
the deed
There
which
a
has been
record of
shown.
right is there. You are showing.
So
that
I
is
am
the
showing the
owner.
record of right now. Lordship is on the view that that I am.
I am not in the view. We have to convince the court.
So that
there are some
that the deed
arbitrariness.
that the
Certain
deed which has been they have
arbitrariness.
mentioned.
No,
Lordship,
no,
kindly consider one aspect, lordship.
no,
That the deed which they have mentioned, lordship. If I obtain the
you are
certified
not
copy of
unsuccessful, you cannot appear.
no, lordship, I am not on that, lordship. Kindly
Yes,
consider
that is
that
only
one
the
aspect. I am only on one aspect, lordship. That so far the deed which has been mentioned is concerned, lordship. If I obtain the certified copy of the deed, I can show you that
that is purely your dispute.
no,
not
lordship,
before
it's
this
not
court.
purely my dispute, lordship.
Yes.
If someone has no go down, lordship, he has been selected, lordship. So how can I agitate, lordship? I am the second person who has been most eligible candidate.
Now you are challenging the report.
No, I am not challenging the
backing
report,
up on the
lordship. I am
report
not
and now
challenging the
challenging the
report. I am on the report, lordship, that what they have referred, I am pointing out that the references, lordship.
Very good.
That's so far the reference is concerned.
No more.
Lordship, even he is aggrieved. Even he is aggrieved.
Let me agree.
It is not admitted, but even if he is aggrieved,
Let me agree.
his remedy doesn't lie here. His remedy doesn't lie here. His remedy lies before the suit court.
Now, how can I challenge before the suit court?
এটা আমি বলবো না নিজে
Okay, please take down.
Lordship, I have to come back with the certified copy of the deed, lordship. But otherwise, I can establish my case, lordship. Because I am saying, lordship, that the property which has been shown, that is 400 square feet, lordship.
Who are you?
So, lordship,
who are you? Whether you are the owner or co-sharer?
I am not the owner, lordship. I am the contesting.
Mr. Karar, you know the differences.
No, lordship. That
one person have only share of 1 decimal, but he can possess 5 decimal. As because the arrangement between the parties.
Lordship.
If you one of the owner, you can raise objection. If you not the owner, you cannot raise any objection.
I understand.
They have already constructed. They go down over a plot of land, and there is no such objection.
My submission is that, lordship.
Your submission is otherwise.
It's a house, lordship.
Whatever may be.
So now, lordship, let an opportunity may be given, lordship. I added him as a party, lordship. Lordship, kindly feed another day of hearing, lordship. But otherwise, I will pay you.
No, lordship, I am opposite.
Lordship, because if I am not, I can fail to show that, lordship, he is not living in the possession of the more property.
Very good, very good.
Transferred from the record itself.
Today,
from the inquiry report.
Okay, hard, not more. Written exception. Exception to the report filed by the respondent number 5 be taken on record.
Full stop.
Petitioner is one of the applicant of vacancy ID of a vacancy notification issued by Subdivisional Controller Food and Supply Malda on 13th of May 2024 for appointment of FPS dealer. It is the contention of the petitioner that he is the most suitable candidate, but the petitioner has selected another person. He has also challenged the rejection of the candidature. He also challenged his rejection. her rejection by the concerned authority. Petitioner has made a detailed representation to the concerned authority, but the authority concerned has not acted upon his representation. Hence, this writ. During the course of hearing of the instant writ petition, the subdivisional controller food and supply has submitted a short, brief history of statement of facts. It appears from the report that 5 persons, including the petitioners, applied for the license, have applied for the license. Out of 5 applicants, only 3 candidates, namely Firoza Parveen, Mumtaz Ali, and Samad Sheikh, found to be eligible. The petitioner Firoza Parveen, now it has further reported that the petitioner Firoza Parveen, though found eligible, but was not considered as a most suitable candidate. Applicant named Samad Sheikh was recommended for the license as a most suitable candidate. It is further reported that during the course of the proceeding, proposed shop come go down of petitioner as well as Samad Sheikh was inquired by the concerned inspector, and they submitted a report. On the report, it appears that Samad Sheikh have ownership over the proposed go down, but petitioner Firoza Parveen is possessing the proposed go down through a long-term lease agreement. Structure of Structure of roof of Samad Sheikh was made up of concrete, where roof of Firoza Parveen is made up with tin without coating of any bitumen. Regarding completeness of go down, it is reported that Samad Sheikh's go down was complete in all respect, but the go down of Firoza Parveen, a petitioner, was incomplete as roof was tin shaded without coating of bitumen. The report was placed before the concerned district level fair price shop selection committee. Full stop. The said committee, after perusal of the report, recommended Samad Sheikh to be a most suitable candidate. Full stop.
Lordship is, I am so, pardon me, Lordship, for interrupting. Since Lordship is recording everything, Lordship kindly also records that the petitioner's go down is not located in that moja also, where the ye has been floated.
My distance is from the center
No.
of the sun is 200 meters.
It has been recorded in the.
Where it was reported? Where it was reported?
If Lordship kindly comes to page number 18 of the report, Lordship, once.
18.
18, 1-8.
But in the report, it was not stated like that.
Yes, yes. But it has been specified in the inquiry.
Page 18.
Page 18. Yes, Lordship. 69. Serial number 69. The proposed shop come go down
Notified
is
Mauja,
not located.
but located
Yes.
under service area of
Yes.
Janutola. But within
Yes.
the Mauja, you cannot object whether it is maybe. That's why it is not placed in the
Yes.
record. That's why it is not placed in the report. Okay. কি বললাম বলো? Samad Sheikh to be the most suitable candidate. Full stop. The report contain inquiry report, detailed inquiry report conducted by the concerned SCFS, conducted by the inquiry officials of the concerned SCFS in respect of both the petitioner as well as Samad Sheikh. Peruse the report. I have also perused the marks scored by the petitioner as well as the Samad Sheikh. From the score, it appears that the petitioner has scored 66 marks, while recommended
73.
candidate, namely Samad Sheikh, scored 73 marks. Full stop. Next paragraph. By filing an exception, the petitioner has placed on record certain discrepancies in the report and the assessment by the concerned authority regarding ownership of the selected candidate. Full stop. The copy of Khatian number 2827 within bracket of Samad Sheikh, bracket close, was placed, and learned counsel of the petitioner submits that the portion of area recorded in the under the same Khatian in plot number 510 is not the area which was covered the proposed shop come go down of Samad Sheikh. He further pointed out that the proposed shop come go down of the petitioner of the petitioner
Of the person who has been selected.
is beside the PWD road, but shop come go down of Samad Sheikh is not over the PWD road. He also pointed out that the plinth height as recorded by the inquiring officer is different in the inquiry report as well as the sketch map appended with the inquiry report.
And also one point I have missed, Lordship, that is that there is a toilet within the godown, Lordship.
Not within the godown.
Within the
Not
godown.
within the
So far,
godown.
so far the stage map is concerned.
Lordship kindly sees not within the godown.
Having heard the learned
There is
counsel.
existing of toilet within the godown. That is my submission. Lordship. Kindly record
No,
my
no.
submission. No, Lordship, kindly record my submission.
How?
Lordship,
Where is the submission, basis of the submission?
no, Lordship, I'm
You may submit any everything.
No, Lordship, kindly come to the.
I shall not take up any on such a submission.
Lordship, it has been shown, Lordship. Then after godown, there is a bathroom.
After go down, there is a bathroom. What does it mean?
Lordship, kindly see the photograph, Lordship, at once, Lordship, at page 9.
Father, Mr. Karan, what are you doing? What are you doing for this?
He's showing toilet.
No. There may be a toilet or otherwise with outside the go down.
I am. It is following from their document, Lordship.
Whether that portion was shown,
Yes, your Lordship.
not go down 1, go down 2 and office.
Yes,
That is the only way.
No, Lordship, that measurement is.
Mr. Karar, you are just.
Lordship. Kindly,
Okay,
Lordship.
no.
Measurement is showing like
No,
that.
no.
Lordship will come, Lordship will find, Lordship.
We had the learned counsel for the parties. I have also considered the report and the exception placed by the petitioner. It appears that the report is very much clear on the fact that the petitioner has scored less marks only due to the nature of ownership and incompleteness of go down at the time of inspection. The exception to the report has not disclosed anything before this court regarding the observation in the report. It has been proved that the present petitioner has a position over the proposed go down through a long-term lease. Otherwise, on the other hand, the selected person has ownership over the plot of land. The record of right as placed by the petitioner showing the right of the selected person over the plots of land. The area appearing in the area and the share of Samad Sheikh appearing in the LRR cannot be calculated accurately to calculate the area and nature of and an area possessed by the said Samad Sheikh over the said plot of land. However, the incompleteness of go down of petitioner is appearing.
I am interacting, Lordship. It
Not interact anything during the. What are you doing like that? No, thereafter.
Page number 17, Lordship.
After that, I shall not hear any of your. I am passing the order and you are doing like that.
It cannot.
No, you just stop and sit down. Incompleteness of go down of the petition has no answer. Under the above observation, I find no justification to entertain the writ petition. The concerned authority has acted according to the law. This court being a writ court is not the appellate authority to this court, being a writ court is not an appellate authority over the decision of the state or respondent, over the decision of the order of the state respondent. Full stop. There may have some wrong recordings during the inquiry, but such recordings cannot disentitle the selected candidate for getting license. Moreover, no apparent arbitrariness or malafide has been proved before this court. Thus, I find no justification to entertain. Writ petition is thus disposed of.
Grateful.
Next.
My lord, before passing the. My lord, before taking the 12:30 matter, can the passover matter be taken up?
Passover matter now, 12:30 I have fixed matter. I have to take up this matter.
My lord, then my lord, kindly extend my interim order.
If I can extend the interim order, no issue.
Kindly extend the interim order and fix a date for hearing, my lord. 10:30, my lord, my senior.
So you have submitted a lot.
Your lordship's query is concerned, I am giving a reply. So for my landed friend party is concerned, he has been conclude his part. So for my query is concerned, it has continued. Your lordship pleasure, my lord, that matter should be heard and disposed. So my lord, your lordship peremptorily fixed on 10:30, but my lord, unfortunately, I was walked on before the Chief Justice. Thereafter, I am coming. So your lordship can.
No. আসুন লিখেছি ডায়েরিটা নিয়ে আসুন কালকে 10:30 থেকে আসুন
এই 11 থেকে 14 নিয়ম, কারণ আমি থাকবো, আমার বাচ্চাদের নিয়ে ডাক্তারের কাছে যেতে হবে। হ্যাঁ,
কালকে দেখুন 7 তারিখ
দর্শক খাতা দেখছি, পত্র দেখছি,
কিছু নেই। Tomorrow 10:30. Tomorrow 10:30.
It is my pleasure.
Yes. Item number 4
of your lordship.
Let the matter appear in the list tomorrow under the same heading, same time.
So carried, lordship.
Interim order passed by this court on the earlier occasion is further extended till tomorrow. Call fixed matter. Item number 5.
Item number লিখে দিই।
I was addressing your lordship the last occasion. Millard,
I represent Millard, the Asansol Development Authority
Yes.
with Mr. Chatterjee. আমার নোটটা দে Millard, the land which was Millard essentially belonged to the government, Millard, that was granted to this petitioner, Millard. And Millard, the lease was executed by and between the parties.
Yes.
Now, Millard, I raised, Millard, certain points on the last occasion for your lordship's kind consideration. That, Millard, the prayer for Millard executing a project, Millard, which is essentially commercial in nature, and there is, Millard, a fundamental transfer, Millard, a fundamental change, Millard, in the project. Millard, 32 numbers of flats, Millard, were, Millard, contemplated that by the petitioners, Millard, considering, Millard, the ground reality and, Millard, the growing demands. So, Millard, they also prayed for, Millard, widening of roads. The authority, Millard, while considering the prayer, Millard, had, Millard, imposed certain amount as a development fees.
Conversion charge.
Conversion charge. Now, this conversion charge, Millard, according to them, they, Millard, prayed for that they said that the amount as that was imposed by the authority, Millard, this is an astronomical amount and this should be less. At the cost of tiring repetition, I respectfully submit, Millard, that the amount was disputed, but the jurisdiction of the authority to impose such amount was not disputed. Am I clear to my lord?
Yes.
And this was done, Millard. The impugned order was, Millard, passed way back in, Millard, 2017. Huh? Yes, 30th May 2017. Millard, kindly takes pain to turn P5, page 30, page 59 of your lordship's brief.
You are there up to page 60, wherein they have admitted your conversion charge.
But they said this amount should, the extent of amount.
Yes.
So, Millard, the jurisdiction of the authority now, Millard, the cause of action, Millard, normally, Millard, your lordship has taught us many a times that while filing a suit or a writ petition, 3 certain things are required to be, Millard, considered: that limitation and jurisdiction and cause of action. Cause of action, it constitutes bundle of facts. 2017 order, Millard, that gave rise to, Millard, the petitioner to come before your lordship.
Yes.
Now, Millard, this writ petition has been filed in 2022. Now, my lord, I request your lordship, my lord, in this context, my lord, to take pain, my lord, to take note of, my lord, the section 46 and section 47 of the West Bengal Town and Country Planning Development Act 1979.
Provisions of appeal. Appeal provision.
Appeal provision. And my lord, the project report, the application, page 58. My lord, the third paragraph, consider, this is, my lord, that the second, we have invested huge amount for the plot of land. Many of our relatives as well as friends are pursuing us for their residential house at Durgapur. As the residential lands are limited in the hand of ADDA, so they are not fulfilling the demands of maximum who are applying to our ADDA for their own residential land. So ADDA is planning to distribute the plots of land in the form of cooperative housing society, by which in the limited land, maximum residential house may be constructed and by which they may please most of the applicants. Considering the above, we have also decided to construct group housing cooperative society. As per views of our architecture, we may construct 32 numbers of flats and the said 18.13 katas of land. We may provide 32 families to their residential flat, and the pressure of the ADDA for demanding residential house may be partly decreased. We also come to know that recently a plot has been allotted to a group of housing such and such.
Yes.
Ultimately, my lord, kindly see the last paragraph. It may also be mentioned for your kind notice that on reply of my friend Sri Amit Saraf, such and such, that is way back in 2012, who is also very much interested for residential flat at Durgapur and applied ADDA numerous times, but in vain. ADDA has informed such and such that the said land may be converted to a group housing cooperative society if the prayer may be put up for the honorable board of the ADDA. So essentially a prayer of conversion. And then the enclosure.
Yes.
The enclosure, this was, Millard, they mentioned, but this was not given. Now, Millard, the opposition, page 16 of our opposition, R3,
Page
16 of our opposition. They mentioned this, Millard, but it was not annexed with the writ petition. Possibly, Millard, by omission. It happens many a times, Millard. Ganapati Group Housing Cooperative Project Report. Now, Millard, this is Millard G plus 5 stories apartment building for Ganapati such and such. Why I tell your lordship, Millard, after that I will take your lordship's kind attention, Millard, to the lease deed executed by and between the parties. Millard, the subsequent pages, it clearly depicts the contour of the entire project. Essentially commercial in nature, growing need of the housing, everything, widening of the roads, everything. So, Millard, essential nature is the fundamental thing is, Millard, for conversion. And in page 60, I will not, Millard, burden your lordship with the same thing, but page 60 indicates, clause 2, that they are only disputing, Millard, that this amount should not be X, but X minus Y.
Amount is exorbitant.
Exorbitant according to them. And
they are
prayed
ready
for,
to give the amount
and Millard, 20 feet wide road, that should be, Millard, such and such a katas of land. Now, Millard, Millard, why I took my lord's kind undivided attention to this, Millard, agreement, the clauses, the commercial. First of all, Millard, the normal law subject to correction, Millard, parties are bound by their contract. Unless, Millard, contract is rescinded on the ground, Millard, mentioned in, Millard, the Contract Act. Now, Millard, this is not a case, Millard, subject to correction, Millard. The Contract Act says from 16 to 20, Millard, that what are the, Millard, grounds by which it is neither, Millard, hit by the doctrine of frustration, or, Millard, it does not say, Millard, that the contract is, Millard, incapable execution for supervening impossibility. So, Millard, today, page 25 of your lordship's brief, Millard, paragraph 12, page 12, clause 12, page 7, internal page 7.
Page 25.
Page 25, Internal page 7.
Yes.
Yes, 10. Not to assign, underlay, or part with the possession of the demised layout plan and the buildings erected or to be erected thereon, or any part thereof, without first obtaining the consent of the lessor in writing, in any event not to any person who is not qualified to be an allottee, such plot of land, the land acquisition and the development scheme rules for the West Bengal, the government and lessor shall have the right to impose such condition as it may think fit, including charging difference of land premium in the event it decides to grant consent to the lessee for assigning the leasehold interest in the demised laid plot to any other person. Milord, name 12, Roman 12.
Yes.
Not to transfer or dispose of the lease and interest of the lessee in the layout plan, save and except upon obtaining prior permission of the lessor in writing and subject to payment of requisite transfer fee, as may be fixed by the authority and or as may be amended from time to time, the lessor, along with the difference of the land premium and other charges if any other ground, floor roof construction is completed, and approved plan of local body with sewerage such and such, and the said lease shall be governed by the same terms and condition as the original head lease, provided that for the purpose of this lease, the expressions transfer and dispose of shall include bequest and will made by the lessee such and such, that in the event of bequest by a will of the leasehold interest to any person, such transfer shall be effected only upon grant of probate by a competent court of law, subject to complying with all other conditions set out herein above, including payment of difference of land premium. So Roman 10 and Roman 12, Milord, transfer is not barred, subject to prior permission, and it is, Milord, there is no shadow of doubt, Milord, that when you come up with a project, a deed has to be executed, so it amounts to transfer. So it is not that you cannot transfer. So you are bound by the contract. I said that in respect of this.
No, there is no such transfer like that. They are converting.
No, after the project is completed, then Milord, the 32.
From individual.
32 persons are given.
From individual to group, I said, Milord, there is a fundamental change. It's an application.
No, I understand. There is a change that from an individual to a group. But you have already fixed a schedule to charge the.
I have charged.
Yes.
And not only that, this charge emanates from not only from the statute, but from the contract.
Yes.
I said that the contract is.
How can you charge beyond that?
No, the schedule is there.
Yes, schedule is there for conversion. Charge of conversion is there.
But today, Milord.
Individual to group of company.
Today, the nature, Milord, of the character, Milord, that 1 to 32. Suppose initially it was an application made by the Milord individual. Now I have shown, Milord, page 16, the affidavit from our part. What is the project report? Now, Milord, today, this individual, when it is converted to 32.
Whether it is barred.
Question is, it is not a barred either by the statute or by the contract.
Yes.
Number 2.
If it is not barred, so you may impose some conversion charge. So you have scheduled a conversion charge.
So there has to be a fresh list.
How can you ask for the?
I again, Milord, while I resorting to Milord, clause 10 and 12, Milord, I clearly stated that from individual to group housing, it is a transfer. It is a conversion. Not only that, it's a transfer. Because the clause says that I have to execute a fresh lease. Head lease. I have said, Milord, clause 12. Kindly cease.
Not to transfer or dispose of the leasehold interest.
No, yes, but interest, Milord, part 10, not to assign or part with the possession of the such and such layout building erected thereupon without first obtaining the consent of the lessor in writing. I am the lessor.
Yes, you are the lessor, there is no doubt.
The question is that whether the project report from individual to group, Milord, what is the ramification of such execution of such a project? Number 1.
So there are instances before the ADDA that there are transposition from individual to group, and you have raised the conversion charge for that. You may have it, but
Milord,
beyond that.
Milord, first of all, your lordship has to, Milord, first, Milord, raise the issue of maintainability, not only, Milord, for the appeal provision, but for the delay, my lord, after 5 years.
No, that is you have already argued. I have
Oh,
taken note.
I will, my lord, show a judgment, 2 judgments, my lord, on this point.
Okay.
Section 47. 46. Judge Sahib ke din. Section 46 of the Act 1979. হ্যাঁ দিচ্ছি কপি করতে গেলে কপি খেলা দেখি 46 টা কই any person or body, my lord, got it? Any person or body, my lord, got it? 46. Yes. Any person or body, excluding a department of the central or state government or local authority, intending to carry out development of township project on any land shall make an application in writing to the planning authority or development authority for permission in such form and containing such particulars and accompanied by such documents and plans as may be prescribed. On such application having been duly made and on payment of the development charge as may be assessed under Chapter 9, the planning authority and the development authority may pass an order granting permission unconditionally or granting permission subject to such condition as it may think fit or refusing permission. Now, my lord, in this case, they have accepted that I can take charge, but the amount. Now, the question is, if it strikes, my lord, that your lordship's conscience, it pricks your lordship's conscience that such astronomical amount as that has been determined and imposed, my lord, that is beyond jurisdiction or arbitrary. First is, my lord, my authority. Jurisdiction, when I say, my lord, normally that
you have the authority to impose.
So, my lord, number one. Number two, the 47, it clearly says, page, my lord, this is your lordship, sir. Yes. That appeal against grant of permission subject to conditions or refusal permission. Yes. Any applicant agreed by an order under section such and such, or if no order. So inaction is also, my lord, an action. May prefer an appeal within 1 month of the communication. My lord, this order was passed on 30th May 2017. The date of filing of the writ petition in the year 2022. Now, my lord, they tried to, my lord, the judgment of the Supreme Court. And, my lord, my learned esteemed senior friend, my lord, while arguing, my lord, possibly I may have missed the point, my lord, regarding, my lord, the power of the authority, my lord, to condone the limitation. It must be accompanied by, my lord. Your lordship knows, my lord, under the Estate Acquisition Act, my lord, when I file an application, my lord, before the district judge, it must be accompanied. Yes. Now, my lord, today, the Supreme Court, my lord, that is my understanding of the judgment, my lord. My lord, my lord, I am sorry, it is marked, my lord. 2020, volume 19 SCC, page 681, my lord. Paragraph 19.
Paragraph 19.
19. ছাপিয়ে নে
GlaxoSmithKline.
My lord, may I read for my lord? Page, paragraph 19, my lord, page 704. We may now revert to the full bench decision of the Andhra Pradesh High Court in such and such, which had adopted the view taken by the full bench of the Gujarat High Court in such and such, and also of the Karnataka High Court in such and such. The logic applied in this decision proceeds on fallacious premise. For these decisions are premised on the logic that provisions such and such an act cannot curtail the jurisdiction of the High Court under Article 226 and 227 of the Constitution. This approach is faulty. It is not a matter of taking away the jurisdiction of the High Court. In a given case, the assessee may approach the High Court before the salutary period of appeal expires to challenge the assessment order by way of a writ petition on the ground the same is without jurisdiction or passed in excess of jurisdiction by overstepping or crossing the limits of jurisdiction, including in flagrant disregard of law and rules of procedure in violation of principles of natural justice, where no procedure is specified. The High Court may accede to such challenge and can also non-suit the petitioner on the ground that alternative efficacious remedy is available and that may be invoked by the writ petitioner. However, if the writ petitioner chooses to approach the High Court after expiry of the maximum limitation period of 60 days prescribed under such and such of the Act, High Court cannot disregard the statutory period of dismissal of the grievance and entertain a writ petition of such a party as a matter of course. Doing so would be the treason principle, the dictum of a three-judge bench of Wenchisi. In other words, the fact that the High Court has wide powers does not mean that it would issue a writ which may be inconsistent with the legislative intent regarding the dispensation explicitly prescribed under Section 31 of that Act. This would render the legislative scheme and intention behind the statute stated provision odious. So, my lord, my respectful submission and next judgment. Multiply করিস না ওইটা দে যে লিমিটেশনটা যে ওটা হয়ে গেল হ্যাঁ Milord, one argument might be posed to this court, Milord, honorable court, Milord, by my learned senior friend, that 2020, the next rejection after representation came that the grave is a cause of action. Now, what is the answer of the Honorable Supreme Court in this regard? That does it amount to revival of a cause of action? Milord, this argument of the other side paragraph 6, 8, 10. This is Milord, the 2008 10 SCC, page Milord 115. 2008 10 SCC. Kindly takes pain to turn para 6. May I read, Milord? Para 6. The said original application was transferred from the tribunal to Madras High Court. A learned single judge of the High Court by an order dated such and such held the department failed to establish that it had followed the mandatory requirements of such and such Act by issuing a charge memo, holding an inquiry and passing an order of parliament. He therefore declared that the termination of the petitioner was illegal. As the petitioner was already 59 years old, it was impractical to hold an inquiry on account of employee's health condition. The learned single judge disposed of the writ petition by declaring the petitioner was deemed to have retired from service on such and such and directing that the pension be sanctioned from the date and that the arrears. Now, the paragraph 10, every representation to the government may not for relief may not be replied on merits. Representation relating to matters which have become stale or barred by limitation can be rejected on that ground alone without examining by merits of the claim. In regard to representation unrelated to the department, reply may conform to the matter did not concern of the department or to inform the department. Representation with incomplete particular may be relied seeking relevant particulars. The replies to such representation cannot furnish a fresh cause of action or revive a stale or dead claim. My respectful submission on the same facts, my lord, it cannot be amount to revival. And 2017 and 2020, the condition. And then Milord 2021, then Milord 2022 writ petition filed. I said, Milord, that series of representation, the first representation, Milord,
2017.
30th May. Now, Milord, if he can relate back that no, 1317 admitted that I have not come. But after 1 year, Supreme Court said, Milord, in the earlier judgment, even if the salutary period is over 60 days, Milord had the writ petitioner approached this honorable court within the salutary limitation period, I possibly, Milord, I am debarred from, Milord, raising this question. Now, Milord, this 5 years delay, Milord, subject to kind sanction of your lordship, Milord, the delay defeats equity. It's an equitable jurisdiction at the same time, Milord. But at the same time, Milord, if delay defeats equity, then, Milord, no. For which, Milord, I am not required to, Milord, place in a judgment and to pardon your lordship. Yes. And, Milord, my next limb of submission, Milord, if statute, Milord, if something evil consequences, I repeat, Milord, even evil consequences, Milord, follow from a statute, the court has to, Milord, respect the legislative intent, unless, Milord, a challenge is thrown. The inconvenience or hardship of the parties, Milord, cannot, Milord, destroy the presumption of constitutionality of a statute, even if it affects, Milord, a general interest. It's a commercial matter, Milord. The party in this proceeding, they are contesting a rival claim, and more particularly, Milord, amount. Now, Milord, this claim could have, my lord, generated, my lord, a very, my lord, logical argument. But today, my lord, it is too late in the day. This premise of the argument, my lord, it may be a music to ears, but it did not hit, my lord, the right note. And that is why, my lord, I respectfully submit. And the next question, my lord, next answer, my lord, the state of Rajasthan versus Dr. Lakshmi, paragraph, my lord, 1996, 6 CC, page 445. Paragraph 9 and 10. Now, my lord, kindly it comes to the last page. It's a big, my lord, order. The truth of the matter is that the court will not invalidate an order only if the right remedy is sought by the right person in the right proceedings and circumstances. The order may be hypothetically a nullity, but the court may refuse to quash it because of the plaintiff's lack of standing, because he does not deserve a discretionary remedy, because he has waived his right for some other legal reason. In such case, void order remains effective is in reality valid. It follows that an order may be void for some purpose and valid for another, and that it may void against one person but valid against another. A common case where an order, however void, becomes a valid is where a statutory limit expires, after which its validity cannot be questioned. The statute does not say that the void the order shall be valid, but by cutting off legal remedies, it produces a result. The order or action, if ultra vires the power, becomes void, and it does not confer any right. But the action need not necessarily be set at naught in all events. Though the order may be void, if the party does not approach court within reasonable time, which is always a question of fact, and have the order invalidated or acquiesced or waived, the discretion of the court has to be exercised in a reasonable manner. When the discretion has been conferred on the court may in appropriate case decline to grant relief, even it holds the order was void. The net result is the extraordinary jurisdiction of the court may not be exercised in such circumstances. It is seen that the acquisition has become final, and not only possession had already been taken, but reference was also sought for by the award under section such and such. The order of the appellate court also become final. Under these circumstances, the proceeding may not become final. So, my lord, the 47 says that this has to be filed within 3 months.
1 month. Yes.
No, order to 3 months.
3 months.
So, my lord, today, admittedly, my lord, there was no, my lord, a 1:15. No. It's 1:15, my lord. My lord, I will.
This is the correct.
Oh, and 1 minute left. Now, my lord, I am extremely grateful. Now, my lord, the last order, even if your lordship says, is আমাদের order. The last order, 2021. What we have said, this is exactly, my lord, in line with the judgment we have shown to your lordship. The same thing has been repeated. I did not assign, my lord, any new reason. Kindly see, I referred, my lord, 30th May 2017.
Yes.
Today, my lord, by any stretch of imagination, my lord, the petitioner can say, my lord, that this is a new thing, and my lord, we referred, my lord, what had happened earlier.
30th May 2007.
Right, and we stick to that.
What is the
So
prayer?
today,
What is the
and
prayer?
the stale claim cannot be revived. Otherwise, my lord, my lord got it, the answer. So, my lord, today, your lordship, my lord, kindly have the charity.
30th of May 2017.
Yes,
and
within 90 days, failing which your
11th of
prayer.
November 2021. Both
Right.
is under challenge.
Yeah, both under challenge. But I repeated, my lord, that the consider what I said, I did not assign say, my lord, new thing. I said that you made this application and we rejected it. It's a mere communication, no adjudication. So today there has to be an order. So appeal can be preferred against an order. Appeal can be preferred against an inaction. Now, November 2021, and না দাঁড়া একটু দাঁড়া একটা সেকেন্ড affidavit. Now they can say that within 3 months this writ petition was filed, but the question is, it is a question of revival of the cause of action. Today, my lord, the court cannot lose sight of the fact that the original right between the parties, rightly or wrongly, crystallized on 30th May.
2017.
Yes. So they wanted to revive, which was accepted by them. Today, after acceptance, my lord, the last, my lord, I will show that only 2 judgments the next day, and I will complete. My lord, your lordship has taught us that intentional relinquishment of a personal right is a waiver. When law gives him a certain right and he maintains angelic silence, my lord, it leads to the path of acquiescence.
Okay.
Intentional.
Very well.
Tomorrow হয় না।
Tomorrow not possible.
Tomorrow সম্ভব নাকি? ফাঁকা কোড নাকি এটা? পাঠার তো আছে। না শ্রাবণ মাসেই হবে সামনের সপ্তাহে। মঙ্গল বুধবার হবে।
Tomorrow not possible. Ready আছে। Please take down.
আর 7-8টা বাদ দিয়েছে কেন?
Argument on behalf of respondent within bracket ADDA. Continues. Let the matter appear in the list on 20th August.
Deeply obliged. Deeply obliged.
At 12:30.
Deeply obliged. Deeply obliged.
20 August কিছু আছে?
আরে চণ্ডীদার।
ঠিক আছে। ওকে।
দেখানো হয়ে গেছে। এটা দেখানো হয়ে গেছে। বুঝতে পারলাম।